Good morning, everyone.
Good morning, Chief.
Good morning.
Good morning, Sarah.
Good morning.
Good morning.
Good morning, Commish.
Good morning.
Good morning,
Joe.
other commish. Good. Boy, Joe, you're looking pretty official in the hearing room there.
He's probably not even listening.
Yeah.
Smart guy.
Well, I have so much to say, but so little to convey.
Yes.
I had to come up with a rhyme. I just didn't,
It worked good.
Okay.
Good morning, Commission.
Good morning. Good morning, Eugene.
How you doing today?
Pretty good.
Good.
How about you?
Not bad. Not bad. Thank you.
You got the big presentation to do today.
Yeah, I got some information for you guys to kind of deliberate.
I know on Socorro, I'd gotten that note a couple weeks back.
Okay.
I don't know what the deal was there, but
Yeah, well, that's something I guess you guys gonna have to discuss on the sidebar there.
yeah.
All right, I'm gonna go mute. I just wanted to say good morning to everyone.
Okay.
Morning.
Test, test. Can you all hear me?
Oh, yeah.
Yes.
Good morning, everyone. I'm the guinea pig this morning. It's just me and Christopher Hall in the hearing room. Oh, and Phil. So we're working out all the technical issues here, but I think we're good to go.
Sounded good.
Yeah, Commissioner Hall's gonna love that.
I'm searching for context there, Commissioner Byrd.
I'm here. Sorry, I just couldn't get a
Oh, okay.
thing going here. Good
He's
morning.
nice and loud.
Oh, am I? Good.
Yeah. Commissioner Vicente Aguilar, are you on board?
Yes, Mr. Sherman, good morning.
Okay, Mike. You ready? Let's do a call to order and let's do the roll call.
Commissioner Byrd,
Present.
Commissioner Hall,
Here.
Commissioner Vicente Aguilar,
Here,
Commissioner Fishman,
Presente.
and Commissioner Maestas.
I'm here.
Commissioners, we have a quorum.
Okay, Pledge of Allegiance. Michael, please.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. I salute the flag of the state of New Mexico and the Zia symbol of perfect friendship among united cultures.
Joe, Commissioner Maestas, I like this standing up, and you're going to set a precedent for us now.
That's right.
Oh, I like that.
Consideration and approval of the agenda.
So moved.
Mr. Chairman,
Mr. Chair,
Oh,
Go ahead, Commissioner Byrd.
yes.
Mr. Fisk asked that one of his items be taken off. I don't have it in front of me, but we need to remove that.
Yes, Mr. Chair. This is Russell. Yes, the item that is, excuse me, that is the EPE application for an accounting order. I think is that 19190 or 19180? I'm not sure which one. Let me see.
180.
21180. I'm sorry, not 19. 21180. Yes. That I will place on next week's agenda. Yes, if you could remove that, that'd be great. Thank you.
Okay,
So, Mr. Chair, I'll amend my motion to remove case number 2100180 UT in the matter of the application of El Paso Electric Company for an accounting order governing the treatment of costs related to joining the Western EIM from the agenda
Mr.
and
Chair.
otherwise move it.
I have one additional friendly amendment. If we could pull item B3 from the consent agenda, case 20-00068-UT.
okay. And you want to consider that as a regular item?
Yes, Mr. Chair.
Okay, so we're going to move that to the first item after the consent agenda.
Yes, Mr. Chair, I will amend my motion to incorporate that change as well.
I'll
Okay,
second.
we've got a second from Commissioner Byrd. Michael, would you please take the roll?
Commissioner Hall,
Aye.
Commissioner Fishman,
Aye.
Commissioner Vicente Aguilar,
aye.
Commissioner Maestas,
Aye.
Commissioner Byrd, Commissioner Byrd.
Yep. May have lost him for a minute.
Did we lose him off there? So the agenda is approved by a vote of 4-0.
You don't hear me?
Now we hear you.
Oh, I was saying aye.
The agenda rather is approved by a vote of 5-0.
There we go. Introduction of special guests. Sarah?
Good morning, Mr. Chair and Commissioners. We do not have any special guests or public comment this morning.
Okay, thank you. And next item is a presentation from Robert London. Robert, are you here?
Yes, sir. Good morning, Chairman Fishman.
Oh, terrific.
Can you hear me loud and clear?
I'm sorry.
Can you hear me loud and clear?
Yes, I can. And
Thank
I
you.
think everyone else can too. Are you going to show slides on the screen here?
Yes, sir.
Okay, terrific. I'd ask, we've got several dockets coming up on the electrification of transportation for our IOUs. And I thought it'd be a good idea that before we dig into the details of each of the individual cases, that we kind of get an overview of the proposals that the utilities have made. And just so we have context when we're voting on them. I'm talking with General Counsel as part of this presentation. This is not to consider each of the dockets that are ongoing. It's basically just to get an overview so we have context. And so as not to create potential issues going forward. General Counsel has requested, and I think it's a great idea, that we not ask questions on this presentation. It's just to give us an overview so that as the cases come up, we kind of can put it in context, what the different utilities are doing and what we hope to learn from what they're doing in their initial transportation electrification proposals. So just want to emphasize that's a firm ground rule. Robert, you're not going to get much feedback on this, but just charge ahead and know that we're forbidden from asking questions. We're not ignoring you. Please do, though, take your time going through it. Don't rush through it to be sure that we can, that we're absorbing what you're saying. And if there if there's any unique terminology as you're going through, please explain it because we're not going to have a chance to ask you a question. So do all the commissioners get the ground rules?
Mr. Chair,
Yeah.
so that means we can't ask for clarification or anything, correct?
Mike, I'm going to ask you on that one.
Mike, about that.
Well, Mr. Chairman, Commissioners, really, I think what we were trying to avoid is a discussion of the applications as opposed to if there's something in what Mr. London is presenting that is not clear to you.
Okay.
You can ask him, can you clarify what you're stating? But we just were trying to avoid a discussion because the cases are, several of these cases are still technically open.
Understand. Thank you very much.
Okay, with that, Robert, take it away.
Yeah, thank you very much. And good morning, Chairman Fishman and Commissioners. I haven't met you all yet, but I'm Robert Lundeen. I'm Chairman Fishman's executive assistant. I joined the PRC back in April. And let me share my screen one sec. Okay, can you all see this?
Yes.
So I would just add that I'm going to be presenting on information found in the public record that is available to everyone on eDocket. And with that, I will be excluding discussion of any of the recommended decisions that have been issued in these cases, as they have not yet been presented to the commission by the hearing examiners. But to begin, we got to start with the enabling statute. So back in the 2019 legislative session, the legislature passed 62-812. And the main thrust of the statute is that the public utilities must file applications to expand transportation electrification. And those are the key words: to expand transportation and electrification. The statute also gives a few examples of how the utilities may do that by proposing investments, incentives, different rate designs, and different programs that encourage expanding transportation electrification. Also in the enabling statute is baked in a standard of review for the commission to consider. Obviously, there's the reasonable and prudent catch-all, but there's in addition 5 other standards, such as improving utilities' electrical system efficiency, increasing access to the use of electricity as a transportation fuel to low-income users and underserved communities, reducing air pollution and greenhouse gases, supporting consumer choice, supporting private capital investment and skilled jobs, and providing customer information and education. And then the last is transparency and incorporating public reporting into these plans. So far, 4 of the utilities have filed under the statute. Southwestern Public Service Company, or SPS, filed in the middle of last year. Their case is 20-00150. Currently, that case is fully litigated and a recommended decision was issued back in August. Public Service Company of New Mexico filed at the end of last year. Their case is 20-00237. That case is also fully litigated and a recommended decision was issued in August. New Mexico Gas Company filed under the statute, but their application was only to find that the TEP statute, or Transportation Electrification Plan statute, applies only to the electric utilities. That was confirmed in a final order issued in August. And El Paso Electric Company filed at the end of last year as well, case number 20-00241. That case has a contested partial settlement. A stipulation was filed in June, and it's currently in the post-hearing briefing stage. So for an overview, you can kind of see from this graphic that each of the utilities' plans are largely similar from a broad view. It's only when you get into the specific details and the minutia that they differ. But each utility plan has residential programs, non-residential programs, consumer outreach, budgets, regulatory assets, tariffs and rates, reporting. EP's plan incorporates an impact study, and SPS and PNM's plan incorporate third-party evaluation. So as far as the residential programs for the utilities, again, they're all largely the same, but I'll go through each of them to kind of give the more specific details. SPS has a home wiring rebate, and this is a $500 rebate for residential customers to get the 240 volt installation electrical infrastructure in their home. And that 240 volt installation is I believe it's the same hookup as your dryer. It's more powerful than your standard wall outlet. SPS also offers a low income rebate, which is for $1,300, and it's for the same 240 volt installation. SPS offers the home charging service, which is where they provide the equipment installation maintenance with no upfront cost to the customer, but the customer assumes a monthly rider. And SPS has the EV optimization program, which basically programs charging times into their home charging equipment. Now, PNM has a level 2 charger rebate, and level 2 is the same as the 240 volt installation. Presumably level 1 would be trying to charge your EV from the wall of a regular outlet. Level 2 is the 240 volt charger, and level 3 is the fast charging, which can be anywhere from 50 to 150 kilowatts of power. But yeah, PNM offers a $500 incentive, and that covers the purchase cost of the charger itself and not the installation costs. PNM offers a low income level 2 installation rebate, and this is for low income customers. It's a $2,000 incentive. That amount was increased in a rebuttal position, adopting Prosperity Works position, and that rebate covers the installation costs. Both of those rebates are instant at the point of sale incentives, which means I guess they would be instantly applied to any bill that the customer has for the charger or for the installation costs. And that is a position PNM adopted from Prosperity Works. I guess that is opposed to a traditional rebate where you might submit like a mail-in form and get it later down the line, but for PNM, these would be an instant. As for EPE, EPE has a residential smart charging rebate, which again is $500 incentive. It covers the purchase cost of the charger and not the installation costs. EPE offers a low income smart charging rebate, which is a $2,300 incentive as per their agreement in the stipulation. It covers both the charger and installation costs. And in the stipulation, they have agreed to no upfront payments costs for the low income customers. And again, these rebates for EP are instant rebates as per their agreement in the stipulation.
Real quickly, Robert, on
Yes.
the smart charging, can you give a little more detail about what that is?
Yes, sir. I believe that's just their name for it, just kind of a marketing term. I'm not sure if, I don't believe there's any smart charging procedures built into the program. I believe it's just a naming convention, but I'm trying not to, I don't know the answer, but I'm trying not to editorialize.
Okay. I guess my initial thought is that smart charging means it controls the timing of the charging to maximize grid utilization and minimize cost.
Yes, sir. And I think it's just the name. I believe, as we'll get on later in the presentation with EPE's tariffs, they will propose a time of use tariff that will hopefully encourage the customers to charge at the appropriate times of day.
Okay.
But only SPS has a program dedicated for program charging times, and that is the EVE or the EV optimization program.
Okay.
That you can see on the lower left there of the slide.
Thank you.
Yes. So each of the utilities has several non-residential programs, and these are a bit more varied and a bit more detailed. SPS has the Make Ready Public Charging Stations program. And before we get into it, Make Ready is a term that is used, basically it's the installation of all the electrical infrastructure necessary to install a charger, but doesn't necessarily include the charger itself. It just makes a site or a home or a location ready to accept charging equipment to be placed in there. So the SPS program is for the electrical infrastructure to support 9 chargers in their service area. The customer/site host will own and operate and maintain the charger. It will use a default time of use rate, but the site host may opt out of that. And that is a position that was alternative to a CCIE proposal. The site host would be offered 2 hardware options. And again, that is a position that is an alternative to a charge point proposal. And these chargers would initially come with credit card readers. And that is a position that is alternative to a CCIE proposal. PNM has the Make Ready Public DCFC installation program. And DCFC stands for Direct Current Fast Charging. And this would be the level 3 charging, the fast charging. PNM is offering a $25,000 incentive, and it's for the installation of the electrical infrastructure. PNM also has the Make Ready Public Level 2 installation. And again, the Level 2 charging is that 240 volt charging that I had mentioned. Their rebate or incentive is for $2,500 per port. A typical charging station has 2 ports. It could have more, but typically it has 2 ports. So this incentive would be $5,000 for a charging station, but $2,500 per port. And that was a position adopted from a charge point proposal. This rebate or incentive would cover the installation costs. PNM also has a Make Ready Workplace Level 2 installation. Again, it's a $2,500 per port incentive, which covers installation costs at workplaces throughout PNM service territory. These incentives are again, as I mentioned before, they're instant at the point of sale, which was a Prosperity Works position. EPE offers a DCFC smart charging rebate, and this is for the fast charging level 3. It is a 50% of installation costs up to $26,000 rebate. The rebate would be capped at about $100,000 per site, and that was an agreement from the stipulation. And credit card readers being offered on these charging stations is still a contested issue in this case, and that is written into the stipulation. EPE also has a workplace smart charging rebate, which would cover 50% of installation costs up to $3,500. And this is for level 2 charging, so the 240 volt. And they have agreed in the stipulation to include public access or public charging stations within the workplace program. So continuing with more non-residential programs, SPS also offers a public fast charging program where they propose to own and operate 8 public DCFC stations. These would be initially offered with credit card readers, which was a position alternative to a CCIE proposal, and they would offer a per kilowatt hour time of use rate. PNM has a Make Ready program for low income multifamily housing. It would be a $5,000 incentive per port. It would cover installation costs, and as an alternative position to a WRA proposal, PNM has proposed to duplicate the program for non-low income multifamily housing. PNM also has a Make Ready low income mass transit rebate, and this is for the infrastructure installation costs for depot charging and en-route charging. And unfortunately, I'm not exactly sure what depot charging or en-route charging is, but it is relevant to mass transit, like buses or fleet vehicles. And again, these incentives are instant at point of sale like the others. EPE also has a multi-unit dwelling smart charging rebate, which would cover 75% of installation costs up to $5,200. And that is an amount that was increased and agreed to in the stipulation. It would be for the level 2 charging. And as per the stipulation in that case, hotels would not be eligible for this program. And EPE also has a public transit and fleet smart charging rebate, which would cover 50% of installation costs up to $26,000 with up to $37,000 in Make Ready support. And this would be for the fast charging DCFC. But a part of that program is also 50% of the installation costs up to $3,500 with up to $13,000 in Make Ready support for the level 2 charging as well. Each of the utilities are proposing different tariffs and rates in their plans. SPS has an EV rider, which will be a percent charge to all secondary voltage customers, excluding the lighting customers. PNM has the TEP rider, which would be $1 per kilowatt hour charge to all non-lighting rate schedules. This rider would collect the actual costs from the previous calendar year. It would is proposed to begin in May of 23, and it would be capped at $25,000 a year per customer. EPE is proposing the TEP cost rider, which they calculated to be $0.000176 a kilowatt hour. This would be charged to all non-lighting service customers. As per the stipulation, it would be adjusted on a monthly basis. And as per the stipulation, it would have yearly factor adjustments. So additionally, SPS has the EV optimization rider, and this would be a $50 annual credit for customers participating in their EV optimization program. And also the EV equipment rider would be a $12 a month charge for the customers who take part in the home charging service. And if you recall, the home charging service is the program where SPS provides all the equipment and installation, and the customer just pays the monthly charge. So continuing with the tariffs and rates, SPS has the public electric vehicle charging service rider. And this is basically the charge that customers would pay at the SPS-owned public charging stations. Initially, it was proposed as a per minute rate, but that was changed in rebuttal to a per kilowatt hour rate based on a CCIE and WRA proposals. It would be about 18 cents at off-peak times, and that is claimed to be equivalent to about $2.25 gasoline. The on-peak rate is about double that at 36 cents a kilowatt hour. And there would be a 53-cent a minute idling fee, which is where your EV is fully charged, but it's set or it's left sitting at the charging station plugged in, not doing anything. Their peak period is 12 p.m. to 6 p.m. Monday through Friday, June through September. PNM offers the whole home EV charging rate, which would be for their customers who receive a installation and a charger through one of their programs. It is about 3 cents per kilowatt hour for the 10 p.m. to 5 a.m. off-peak period. And for these customers, PNM would install a smart meter. PNM has the non-residential time of use charging station tariff. And this would be for the non-residential customers who take who benefit from a rebate through one of the non-residential programs. They would pay about an $82 customer charge. They would be charged an on-peak rate in the summertime of about 18 cents a kilowatt hour, and that's from about 5 p.m. to 10 p.m. during the summer. And the non-summer rate would be about 13 cents a kilowatt hour, and that's 5 a.m. to 8 a.m. and 5 p.m. to 8 p.m. All other hours would be the off-peak rate, and that is about 6 cents a kilowatt hour. EPE is a bit different. They have the experimental EV charging rate, and this would be for customers that have a dedicated meter to monitor the usage of their EV charging. It was proposed with the demand charge, but that was later withdrawn in the stipulation. And the rates and charges under this tariff kind of depends on which rate class you're in, but there would be a customer charge that ranged from $0 to about $5. There would be an on-peak charge from 1 p.m. to 7 p.m. Monday through Friday, June through September, and that would range from about 24 cents to 30 cents a kilowatt hour. They would have a super off-peak period, which is a 12 a.m. to 8 a.m. period, and that would be $0.007 a kilowatt hour to $0.008 a kilowatt hour range, depending on the rate class. And their off-peak period would be all other hours, and that again is fractions of a penny, $0.00186 a kilowatt hour to about 6 cents a kilowatt hour range. EP also has the whole house service EV standard and time of day rate. And this would be a per kilowatt hour credit for super off-peak usage. So under this rate, the customers who charge at the super off-peak period would actually earn a credit instead of being charged more. And this credit again, it depends on the rate class you're in, but it ranges from about $0.00178 a kilowatt hour to about 3.5 cents a kilowatt hour. Each of the utilities propose a budget for their plans. SPS has a 3-year plan and a bit over $3 million budget that is composed of about $400,000 for their residential and commercial programs, a bit over $2 million for their public charging program, $350,000 for advisory services, and $150,000 for the third-party evaluator. PNM is proposing a 2-year plan with a nearly $11 million budget, which is composed of almost $2 million for residential programs, $4.5 million for commercial programs, $1 million for marketing, about $1.5 million for their administrative costs, and a bit over $2 million for budget flexibility, which was a proposal of staff that was adopted by PNM. EPE has a 2-year program, about $600,000 total budget, which is composed of about $100,000 for their residential programs, $350,000 for their commercial programs, $37,000 for customer outreach, $70,000 for administrative costs. The cost of their impact study was included at about $37,000, but that was later withdrawn on motion. As per their stipulation, they are agreeing to a 15% budget flexibility, but that is not included in their total budget. And as per their stipulation, they've agreed that if any program spending reaches 75% of its budget, EPE would file a motion with the commission to expand that budget. And with that, concludes my presentation of the summary comparison of the 3 public utility electric plans, transportation electrification plans, sorry. And let me see if I can close out here.
Okay.
All right, well, thank you very much.
Thank you,
for letting
Robert.
me present. Sorry.
Oh, not a problem. Commissioners, any questions or clarifications?
Mr. Chair?
Yeah, Commissioner Maestas.
Yeah, I don't have any specific questions about the plans as we're, to steer clear of that, but I think there are broader questions that we need to discuss. And I think that the appropriate time would be after we have adjudicated all 3 of these plans. Specifically is we need to look at the governor's 2020 New Mexico climate strategy. There's a very distinct chapter on transportation. It's got some really good stuff there, but what I concluded from that chapter in the governor's climate strategy is that there's a lot of other partners involved in this to make this a truly a statewide program. New Mexico Department of Transportation is one, Energy and Minerals is another. The DOT has some active contracts with the Institute of Mining and Technology in Socorro, and they have some other contracts that are active. There is an effort afoot, it's a national effort through the Federal Highway Administration to designate zero emission vehicle corridors. And obviously these are, interstate and arterials that would be probably first in line for public electric vehicle charging infrastructure. So I think we need to look at that. We need to chat about the rulemaking timing. It would be great if we could champion some kind of cooperative effort with the legislature to enact electric vehicle purchase rebates. I think Excel Energy in Colorado is, I think, the only investor-owned utility that does offer those rebates for EV purchase, because obviously that is the ultimate barrier to the expansion of EV ownership. The other thing I think we should talk about in that is the more of an exact set aside for low to moderate income communities. As an example, community solar has a specific 30% set aside on a project by project basis. This legislation simply has a requirement to consider low to moderate income communities, which are prominent, I think, in all 3 plans. So I think we need to think about that. Also, there are some differences, there's no doubt, in these plans, and the legislature fashioned this statute or structured it as a pilot. It's a 3-year pilot. And my office had submitted some questions in the form of a bench request, soliciting ideas for standard metrics. That way we're not comparing apples to oranges, and that we can report to the legislature after 3 years how we define success in the form of these metrics. And the last thing is, it's no secret that this statute only applies to investor-owned utilities. The rural electric cooperatives are not required to participate. And so there needs to be maybe a softer program that encourages the rural electric cooperatives to coordinate with IOUs, especially those rural electric cooperatives whose service areas are adjacent to the investor-owned utility service areas, to truly make this a statewide effort. So I think there's a lot of questions, Mr. Chair, but I think the appropriate time to have that discussion would be when we take action on all three of these plans. But I want to thank you, Mr. Chair, for having Rob bring this forward. I think it gives us a better perspective and context on what we're looking at in the first generation transportation electrification plans, because I think we all know that this is the future. And so I want to make sure that we get it right, and that this pilot really be not just a success, but a springboard toward a major increase in electric vehicle ownership. Success in other states comes from their governor establishing a specific goal for EV ownership. The governor's climate strategy does not have that. So I think that, when you set a goal, I think you're a little more focused in achieving that in terms of EV ownership. So I think that's something we need to consider as well. That's all I had, Mr. Chair. Thank you.
Thank you, Commissioner Maestas. Other commissioners?
Mr. Chair.
Commissioner Hall.
I thought that last point that Commissioner Maestas made is very important, really, establishing a goal. And since it's absent from the governor's plan, I don't know that we're in a position to establish one. But having said that, I think it's something to maybe bring up, maybe with the legislature. But I do think that my understanding is that one of the biggest barrier to EV adoption is support for the use of EVs through the provision of charging stations. Certainly, early adopters are the ones who are going to buy the vehicles first, and then as they age out and become sold in a used market, later adopters will purchase the vehicles. But, there's an indicated appetite for purchasing vehicles, but without the infrastructure, that's a big disincentive, to purchase them. I did have a question. And my question can certainly be vetted through Mike about the supercharger rates that I think it was El Paso Electric charged that were very low, but they were between the hours of 12 and midnight. Do those come into play, for example, Robert, if the charging begins before midnight? I mean, in other words, do you have the regular, whatever the charging rate is at 11 o'clock, but then when 12 o'clock occurs, then are you bumped down into the supercharge rate? How does that apply? And Mike, is that okay to ask? Michael?
I had to unmute myself. I'm not familiar with the EPE proposal. If that's something that Robert can answer, because it's directly stated in the application and supporting testimony, then I suppose he can answer that to the extent.
It was on his table. That's what caught my attention. So
to the extent it's factual.
Yeah, only factual.
Yes, Commissioner Hall, I can attempt to answer that question. So I guess it depends on which tariff we're talking about, but for their experimental EV charging rate, that is for customers that have a dedicated meter just for their EV charging. And I believe under that circumstance, the on-peak, super off-peak, and off-peak rates would all cover the times of day. So in that case, if someone started charging at 11 p.m., then that would be 1 hour of probably the off-peak rate, and then the rest of the time on the super off-peak rate. That's so. Let me couch that by saying that's my interpretation of the plan. I am not an expert on these plans, even though I've pretty much read everything in the public record. So there's a potential that could not be true, but I believe in the best of my knowledge that would be the case.
Okay, thank you very much. That's some information. I appreciate it. That's how I would interpret it, but I just wasn't sure. Okay.
But so let me just clarify some more. So their TEP cost rider would recoup their plan costs, and then their third tariff rate was the whole house service EV standard and time of day rate, and that would be the credit. So sorry, let me just scroll back one sec. So they don't have like some of the other utilities had a rate attached to the chargers themselves, especially the non-residential chargers. I don't believe EPE is proposing any rates of that sort. So the owners of the chargers themselves would probably be able to set the rates. But yeah, for the home charging, for the customers with a dedicated meter, if they didn't have a dedicated meter, I assume that the customer would just pay their regular rate schedule that they're a customer of.
I see. Okay. That was the context I was imagining that applied in. I don't have the graph, your table in front of me to refer to, but I think that was I think they were home-based meters. Anyhow, thanks very much. And thank you, Mr. Chair.
And I apologize if my answer was rambling or confusing.
No, it's fine.
Any other commissioner comments, questions? Okay, great. Robert, thank you. Nice job of giving an overview. There are differences between the utility programs. In a way, I think that's a good thing because we can learn from different approaches while we're in this early phase. And I just want to echo Commissioner Hall and Commissioner Maestas in saying it would be great if in follow-up legislation there were some goal setting. Because when you have a goal to hit, sometimes you get a lot more inventive and creative and focused when there's a specific goal to reach. And, this is a start. It's a fairly small start, but, we're moving on it, and that's a good thing. So with that, let's get on to the next item in the agenda. And we're on to consideration and approval of prior meeting minutes.
Mr. Chair, I'll
The
move.
minutes as presented.
I'm sorry, I think did we have two motions to approve? One from Commissioner Byrd and one from Commissioner Hall?
Yeah, I'll second.
Okay, great. Any comments from commissioners? Michael, please take the roll.
Commissioner Maestas. Commissioner Maestas.
Aye.
Commissioner Vicente Aguilar.
Aye.
Commissioner Fishman.
Aye.
Commissioner Byrd.
Aye.
Commissioner Hall.
Aye.
The open meeting minutes for August 18th, 2021 are approved by a vote of 5-0.
Okay, we are on to consent action items. And Michael, would you please read them? And noting that item number 3 has been moved to the regular agenda.
Commissioners, the consent action items that you would be voting on are case 21-00203 TRM in the matter of the application of Empire Transportation LLC, DBA Empire Transportation, for a certificate to provide non-emergency medical transport service. This is a potential order regarding the assignment of a hearing examiner, case 21-00206 TRM, in the matter of the application of Duke C. Rides LLC for a certificate to provide non-emergency medical transport service. This is this is a potential order regarding the application for certificate. Case 21-00221 UT in the matter of the application of New Mexico Gas Company, Inc. for a variance from Rule 1710-640 NMAC for its September 2021 gas cost factor statement. This is a potential order regarding the application for variance. Case 21-00219 TREN in the matter of the investigation of Albuquerque Ohana Movers LLC. This is a potential order regarding a petition for order to show cause and cease and desist order.
Excuse me, Mike. This is Sarah. I'm sorry. I think that last one is a part of a regular action item.
Oh, you're right. Thank you, Sarah. I jumped right over the little line at the bottom of the page.
Oh, let him go.
I would have just kept going, so thanks.
Yeah.
Yeah, thanks a lot.
Commissioner Byrd, just, rein it in. Do we have a motion to
Move to approve as amended.
As amended, thank you.
Second. I'll second that.
Okay. Mike, would you take the roll?
Commissioner Maestas,
Aye.
Commissioner Hall,
Aye.
Commissioner Byrd,
Aye.
Commissioner Vicente Aguilar,
Aye.
and Commissioner Fishman.
Aye.
The consent action items I just read and not the one regular action item I did read are approved by a vote of 5-0.
Okay. And so now we're on to regular action items. And we'll start with item number 3, moved from the consent agenda, in the matter of the formal complaint of Don Sanders against CBG Maintenance Water Company. And Hans?
Yes, thank you, Chairman Fishman. Good morning, Chairman and Commissioners. The formal complaint in this matter alleges that the complainant was overcharged water usage rates and asks for a credit to their account. The formal complaint was filed on March 13th, 2020. The CBG Water Company filed their answer on April 20th, 2020. Commission issued an order for staff response by July 22nd, 2021. And staff filed their response on August 24th, 2021. CBG responded that they denied that they have charged any rates over the approved rates and that this complaint had been reviewed and dismissed by the CRD division, who had worked out a payment plan for complainant CBG to satisfy the informal complaint. Staff reviewed and recommended dismissal of the complaint brought before the commission based and indicated that CBG Maintenance has, in fact, in good faith, made all efforts to work with Mr. and Mrs. Sanders in keeping the account current. I did note that staff did find, after a accounting of all the rates that were reviewed by staff, that they did find $20 of reconnection fees, which is 4 times $5, should be credited to complainant. However, staff did note that CBG has on other occasions waived the reconnection fee multiple times for the complainant and made numerous other credits in working with the complainant to keep the account active. Complainant in regards to the informal settlement, the complainant has made 6 out of the 22 payments towards the agreement in keeping that active. But based upon staff's review, they did not find that any rates have been charged above the approved rates, and those were all edited out. And based upon staff's recommendation of dismissing the complaint I recommend dismissing the formal complaint.
So Commissioner Maestas, what were the issues you wanted to consider here?
Mr. Chair, thank you. I just had one question regarding the timing of the commission order for staff response. It was more than a year after CBG's answer that was filed on April 20th of 2020. Why did it take so long? And were there any violations of due process or violations of our own procedure? So that's my question. Why did it take over a year for the commission to order a staff response?
Commissioner Maestas, I respond to that. There was an initial motion to dismiss filed by CBG that Office of General Counsel was reviewing. And in kind of, I did want to give a little bit of time allotted to see if the informal agreement that had been reached with CRD was actually going to be adhered to by the complainant and by CBG Water Company, or if this filing of the formal complaint was really a way to kind of get around that settlement. That being said, there was a little bit of time lapse on my part, and I'll apologize to the commission for that. In terms of the order for staff response could have gone out a little bit earlier. But it was kind of brought back to my attention in talking to utility division staff. So there was a little bit of a delay here in getting staff's response and in determining whether we wanted to do an order for staff response before addressing the issues of the motion to dismiss filed by CBG, but we ultimately decided that we did want staff to weigh in on some of the issues. So just making sure that everything had been addressed from a due process potential, really.
Thanks for that explanation, Hans. And I know I've made compliance tracking an issue, and this isn't quite compliance, but this was a potential due process tracking issue. So I still have my sights set on some kind of compliance process within the utility division, even if it's a cadre of existing staff that may have collateral duties assigned to tracking compliance and tracking due process. So, and perhaps on the due process side, maybe this is a shared responsibility with Office of General Counsel or the legal division. So thank you, Hans, for that explanation. But I'm still going to pitch for, I think, tighter internal compliance and tracking on these issues. That's all I had, Mr. Chair.
Okay, thank you, Commissioner.
And I'll move to approve.
Second.
Mike, could you please take the roll?
Commissioner Vicente Aguilar,
Aye.
Commissioner Hall,
Aye.
Commissioner Byrd,
Aye.
Commissioner Fishman,
Aye.
Commissioner Maestas.
Aye.
Commissioners, the order is approved by a vote of 5-0.
Okay, so we're on to regular action items. And we're talking 21-219 TREN in the matter of the investigation of Albuquerque Ohana Movers LLC. Hans and Jesse, please lead us.
Thank you, Chairman Fishman. This matter comes before the commission upon the staff's petition requesting issuance of orders to show cause and to cease and desist. Albuquerque Ohana Movers was brought to the attention of the commission based upon an informal complaint due to AOM not completing a move of the complainant, transportation staff reviewed and reported that AOM has been operating without a certificate from the commission for at least 2 years based upon admission of the owner, and potentially since 2012, based upon when the county license was applied for. Staff has requested that AOM be set in order to cease and desist its operations and show cause why it should not be fined for violations of the Motor Carrier Act. The commission issued an order to cease and desist on August 30th, 2021, which also requested that AOM complete an application to the Transportation Division by September 24th. The proposed order then would then require AOM to file a response as to show cause why they should not be fined for violations of the Motor Carrier Act by operating as a specialty moving company without a certificate. The order appoints a hearing examiner to set an expedited hearing and to make a recommended decision to the commission as to if AOM's operations prior to the order endanger the public health and safety, and any proposed fines or penalties that should be made for violations of the Motor Carrier Act. With that, I'll stand for any questions.
Mr. Chair.
Commissioner Hall.
I just have one question. Hans, I noticed you said expedited hearing, but I don't think the order reads that way. It just says appoints a hearing examiner. The commission hereby appoints a hearing examiner to conduct a public hearing. It doesn't specify expedited, so is that what you want?
I will add that. I will add the expedited language to that section of the order.
Okay.
As amended then.
Thank you, Mr. Chair. And if there's no other discussion, I'll move the order.
Yeah, no, I had a question about, I guess we just use the word expedited on so many things. And I'm wondering if there is some reason that this should be expedited or just be treated as a normal.
There has been some back and forth discussion within the Office of General Counsel regarding the statutory language here. To me, the statutory language would protect an operator whose license that we are suspending, and that maybe we do owe due process to hold an expedited hearing if we are suspending their certificate. In this case, however, to me, this presents an operator that never had a certificate in the first place. And do we owe that same expedited hearing to them when technically they shouldn't be operating if they haven't gotten a certificate in the first place? So we have had some discussion back and forth with the Office of General Counsel as to the due process standard. Do a company, I mean, these are fairly rare cases here where we have an operator that is operating without a license. And if those same statutory protections of an expedited hearing should be in place, technically they shouldn't be operating without a certificate, without a completed application for approval before the certificate. So we are aware of that, and with our hearing examiner schedule, the proposed order also gives the hearing examiner leeway to adjust those guidelines accordingly, as our hearing examiners are running on very tight schedules right now. So between asking, we've already asked AOM to complete their application by September 24th. If they complete it, there's the 20-day waiting period while we notice their application out. To me, there seems to be a good period of time under regular circumstances to have this heard. It's fairly straightforward. But I understand your concern, Commissioner Fishman.
Yeah, it's not a hang up on this particular case for me. I just want us to get a lot more discerning. about when we should slap that expedited on, and just something to look out for in the future.
Mr. Chairman, this is Michael Smith. I just wanted to add, the reason that we include an expedited hearing is because actually the rule provides for that allows us to summarily, on an ex parte basis, issue a cease and desist against a carrier who is in violation of the safety or insurance provisions, requires us to do an expedited hearing. And that's consistent with the way ex parte applications are handled in the district court and as well. And the basis for that is that because you're taking action without giving the party against whom the order is directed an opportunity to respond and present a defense, the rules provide that you provide them that opportunity as soon as possible in case there is a defense that they have to provide. Here, the presumption and the basis of the order is that they don't have a certificate of authority, but I think it's still proper and consistent with the rule to provide them the opportunity to make a defense if they actually have any as soon as possible, and that's on an expedited basis.
You know, Mr. Chair, I tend to agree with Mike's reasoning, and I know it seems that given the mandatory, time frames that apply, I guess, anyhow, even if we were to call it expedited, the notice period and so forth, that the hearing examiners can probably work it into their schedule effectively since there is some time in which they could do that anyhow. So I don't think I'm troubled by the use of that word in this case.
Okay.
I think it's probably appropriate.
This is not a make or break for me, so I just don't want to get us running in circles expediting everything. And I understand the explanation that Mike just gave.
Yeah.
So,
Mr. Chair.
Yes, Commissioner Mastis.
Yeah, I just had a quick question, Hans. So did Albuquerque Ohana Movers, did they have a certification to operate, 2 years ago? Or was it a new mover that just started operating without a certificate?
To my knowledge, it's a new mover that started operating.
Okay, I guess just one last question is, do we spot check operators that are out there? I know we have a kind of a field compliance, effort, but I'm just wondering how this particular operator can operate for 2 years without a certificate.
Commissioner Mastis, Office of General Counsel recently did have a discussion with Jesse Montoya, since this is the second moving company that we have been notified with in the past month here, operating without a license, as to means and ways of possibly checking, whether it be Googling moving companies in New Mexico and just occasional spot checking. I think based upon my conversation with Jesse Montoya, I believe that he was in favor of incorporating some measures like that. And clearly this is the third order coming up will be the third order to show cause that they have presented to the commission within this past month. So I believe their enforcement measures are on the up. and they are maybe tightening up a little bit. And we have discussed other ways with Jesse Montoya of spot checking, as you are indicating, so that these don't catch us by surprise from a informal complaint being reported to us, that we are more proactive rather than reactive.
Hans, if I may, there are, software programs now that can kind of police the internet. I know when I was on the city council in the city of Santa Fe, we had great difficulty enforcing our short-term rental ordinance and imposing or requiring them to have permits. And the city has employed this software program that basically scans it for advertised short-term rentals, and then they do a cross-check with the actual short-term rental property owners that have legal and active permits. And so there are ways to do this without deploying field staff, and I'm sure we're very limited in our staff resources, but there are other ways to do this smartly. That's all I had, Mr. Chair.
Okay, thank you.
Mr. Chairman, Commissioners, it's Michael Smith.
Sure.
We did have a discussion with the new Transportation Division Director, and we shared some of our past experiences in terms of matters that, I guess, some of the more problematic matters we've had in the past related to enforcement against non-certificated entities. But I do think, while we have some, views about what makes things work a little more smoothly, ultimately, the activity of performing the investigations is something that the Transportation Division handles, and it, rather than, I guess, giving the commission our opinion on things that we're not in charge of, it might be better if the commission wants to hear how those activities, those investigation activities are done. If you actually ask the Transportation Division what they do as a practice. I'm not trying to push off the issue, but we don't advise the Transportation Division. So I don't know that we're the best folks to answer the questions about what Trans is actually doing.
Mm-hmm. So Michael, I was just going to suggest before you made your comment that it might be a good idea in the next month or so for Jesse to do a brief presentation to the commission about how we're addressing this very issue. How do we keep track of folks that may be operating without complying with just basic requirements under the law? So I think that'd be something good to put on the agenda. And Wayne, you might want to, if you're listening, Wayne, arrange with Jesse a time frame to maybe make some kind of presentation to the commission on this topic.
We'll get that done, Mr. Chairman.
Okay, thank you very much. And Commissioner Maestas, you asked the exact right question. Thank you. Okay, anything further? Do we have a motion on this from Commissioner Hall? Did we have a second? I will second if there's not one. And Michael, would you take the roll?
Commissioner Vicente Aguilar.
Aye.
Commissioner Maestas.
Aye.
Commissioner Byrd.
Aye.
Commissioner Hall.
Aye.
Commissioner Fishman.
Aye.
Commissioners, the order is approved by a vote of 5-0.
Okay, we're on to item number 6 in the matter of which is 21 220 TREN in the matter of the investigation of AV Travel Company.
Mr. Chair,
Yes.
so I just want to clarify that the matter was in our previous case that the order would include the word expedited.
Yes.
We discussed that and I thought it should. Okay.
Yeah.
All right, fine. Thank you.
Thank you for just re-emphasizing that. Be
Yeah.
sure we didn't miss it.
Yeah.
Yes, back to 21-220 TREN, and Hans, it's you again.
Thank you, Chairman Fishman. This matter comes before the commission upon staff's petition for issuance of an order to show cause. AV Travel Company was brought to the attention of the commission based upon a complaint due to AV Travel soliciting transportation business at the airport without a contract being in place as a limousine service company. Transportation staff reviewed and reported that AV Travel had been soliciting new business of newly arrived passengers without a prior contract being in place for the transportation of those passengers. Staff has requested that AV Travel be sent an order to show cause to show why it should not be fined for violations of the Motor Carrier Act. I recommend the proposed order as it will assign a hearing officer to preside over an expedited hearing to determine the extent of AV Travel's operations as to AV Travel soliciting business outside the authority of its certificate, and make a recommendation to the commission as to any penalties for violations that should be enacted. It should be noted that the order also gives the hearing examiner authority to extend the hearing time as needed for purposes of scheduling. And just for clarification, AV Travel is certificated as a limousine service company, not as a taxi cab service company. So in properly certificating a limousine service company, there always has to be a contract in place prior to the picking up of a passenger. So that is the crux of the issue here, and that soliciting new passengers without a contract would be outside its certificate. With that, I'll stand for any questions.
Commissioners?
Mr. Chairman, I would like to move the order.
Okay, thank you. Do we have a second?
Second.
I'll second.
We've got more seconds than we need. Mike, can you call the roll?
Commissioner Byrd.
Aye.
Commissioner Hall.
Aye.
Commissioner Vicente Aguilar.
Aye.
Commissioner Fishman.
Aye.
Commissioner Maestas.
Aye.
The order is approved by a vote of 5-0.
Okay. Let's do let's do it this way. Let's take a break. It's 10:42. Let's come back at 11 o'clock because we've got some weighty stuff ahead of us, and we've been going for. No, wait a minute. Let's take item number 7. I'm sorry, lost track of time. Let's do item number 7, and then we'll see if we need a break. Utility Matters 21-190 UT, Renewable Energy Industries Association, formal complaint against PNM, SPS, and EPE regarding utility notices of processing of community solar interconnection requests. Russell, this is a weighty matter. Please take it.
Good morning, Mr. Chairman, Commissioners. Yes, this is a weighty matter. It seems to have come to a nice resolution, though, but we shall see. Can you hear me, Mr. Chairman, first of all?
Yes.
Okay. Okay. So, Mr. Chairman, Commissioners, this comes before you on a formal complaint and a notice of satisfaction of complaint, which under the commission's rules, provides an avenue. There's a special provision of the commission's formal complaint rules that provides that a defendant, or in this case, multiple defendants, can make an offer of satisfaction. In other words, an offer of settlement with the complaining party, the complainant. And that is what happened here. The proposed order would dismiss the complaint as having been satisfied, but would also address the issues that go beyond the complainant's own interests that are of interest to the public in general, because this complaint really addresses matters that are of interest to the public in general, and specifically matters that apply to all potential applicants, current and future and potential applicants for interconnection for community solar projects with the three defendants, which are the three electric utilities. So that's a little overview, but let me get into the details. This matter arises out of the commission's issuance of its order issuing notice to electric utilities and applicants regarding pending applications for community solar interconnections during rulemaking proceeding. That's the name of the order, issued on June 15th in another docket. That was docket 21-112 UT, which is the Community Solar Act rulemaking proceeding. That order required the three investor-owned electric utilities, EPE, PNM, and SPS, to notify current applicants, potential applicants, and as they file in the future, future applicants regarding 2 points concerning the status of interconnection applications for community solar projects pending between now and the time that the commission issues its community solar rules. Those 2 points that were in the notice, which was first a notice from the commission to the utilities, and then part of the order ordered the utilities to provide that information to the applicants. The 2 points are these: that the commission's existing interconnection rules and manual remain in place until amended or replaced by the commission. And number two, a place in the utilities applicant queue for interconnection does not and will not provide any advantage for selection as a community solar project, as the commission's rules will be in place on or before April 1st, 2022. That's the deadlines given in the Community Solar Act itself. The Renewable Energy Industries Association alleges, and I would say correctly, that the IOUs, the investor-owned utilities, violated the commission's order by adding to each of their notices that they would not accept interconnection applications for community solar projects until the rules are in place. So the notices that the three IOUs did included the 2 points that they were supposed to include, and then added this extra language. So let me get into a little bit the details of the complaint. Renewable Energy Industries Association, REIA, states that it is a trade association representing 24 New Mexico companies who are developers of solar distributed generation systems, what we call community solar. In the complaint, REIA alleges that the defendants violated the commission's order, the June 15th order in the rulemaking that required the notice. And that they, I'm sorry, let's see. That the June 15th order, as I said, only instructed the utilities to notify us to those 2 points, and REIA alleges they went beyond that by including the statement about not accepting applications for community solar interconnection. REIA further alleges that the statements that go beyond the 2 points violate the regulations of FERC that implement PURPA, the Public Utilities Regulation Policies Act, that require that utilities make interconnection with any qualifying facility. REIA argues that the community solar applicants for interconnection are asking for interconnection of a qualifying facility, and therefore a refusal to accept those applications would violate FERC's regulations. REIA also alleges that the defendant's statements are in violation of the commission's rules for interconnection of generating facilities not to exceed 10 megawatts. That's Rule 568, 17.9.568 NMAC. REIA alleges that Rule 568 is intended in part to implement PURPA. Similarly, a refusal to accept applications for community solar interconnection would violate Rule 568 according to REIA. I'm going to go beyond, let's see, some of this and the memo, some of the detail to get to where REI goes on to describe staff's report filed by staff in the community solar rulemaking. As described by REIA, the staff report includes as an exhibit a collective form of notice. And REIA uses this collective form of notice because staff states in its report that this reflects the notice that was provided by all three of the IOUs. So REIA uses this as you quotes this language specifically in their complaint so that we can see exactly what language in the notice to which REIA objects. And I noted, I quoted the language in the memo that I provided to you. Unfortunately, I did not underline the part that REIA underlined. So I'm going to point that out to you, the language to which REIA actually objected. I'm going to quote the languages. This is coming from that collective form of notice in staff's report. No NMPRC community solar rules are currently in place, and there are no rules that authorize the processing of any community solar interconnection applications. For this reason, utilities are not required to accept or record community solar applications. And then this is the sentence to which that should have been underlined in my memo, to which REIA objects. However, EPE, PNM, SPS will process qualifying facility applications that are not or will not be associated with community solar programs according to NMPRC Rule 179568 NMAC. So that's the specific language that was underlined in the complaint as being objectionable. REIA asks that the commission order the defendants to withdraw their non-compliant forms of notice and to reissue notices that strike the language, that specific language, and replace it with language assuring that all interconnection applications, regardless of planned business model, will be accepted and processed in accordance with Rule 568. Staff also asked that the commission order staff to withdraw the staff report. So that was the complaint. It was served upon, according to our rules of procedure, it was served upon the three defendants, the three IOUs, along with a notice of formal complaint and order requiring answer. And on August 16th, the defendants, as the three IOUs, filed a joint answer and notice of satisfaction of the complaint. As I said, our rules provide for this specific type of answer called a notice of satisfaction. In the answer, the defendants provide notice to the commission that the complaint has been fully satisfied by agreement between REIA and the defendants. The defendants asked the commission to dismiss the complaint pursuant to the specific rule of procedure concerning satisfaction. And the defendants state that they have reached an agreement with REIA that the complaint will be satisfied if the defendants replace the public notice that's currently on their websites, and that OATIA OASIS has specifically concerns the specific part, interactive part of the website, where I think is where applicants would be obtaining information about applications for interconnection, or actually applying for it as well. The defendants state they've reached that agreement that they will replace their public notices that they currently are with the language to which REIA objects with a form of notice that is identical to the current version, with the exception that the last paragraph, that's the paragraph that's quoted, be stricken and replaced with the following. I'm going to read it because this is obviously very important, this language. It's a longer paragraph, so bear with me. No NMPRC community solar rules are currently in place. For this reason, utilities will not accept or record applications to become a community solar facility whose output the utility is legally obligated to acquire. It is also not known whether there will be NMPRC interconnection rules specific to community solar facilities. However, EPE, PNM, SPS will process valid interconnection customer applications as they would, irrespective of any community solar program. Acceptance, processing, or approval of an interconnection customer application by EPE, PNM, SPS is in no way indicative of subsequent interconnection customer eligibility for any future community solar program under the rules that are yet to be promulgated by the NMPRC. Customers applying for interconnection application prior to the promulgation of such rules bear the risk that the NMPRC's rules could render the facility ineligible for the community solar program or require filing of a new interconnection application under the community solar rules to participate in the program. That's the end of the the proposed revised notice. In addition to publishing that revised notice on their websites, the defendants state that they will send the revised notice to any interconnection customers to whom they previously sent the public notice, the current notice. The defendants state that counsel for REIA authorized the defendants to state that counsel for REIA agrees that the complaint is satisfied with the utilities adopting the negotiated language. Generally, with satisfaction, the defendant would sign the satisfaction as well, or file something indicating their agreement. I think in this case that the commission can accept that the complainant does accept this satisfaction because, one, this language is included, but two, this has been sitting. The satisfaction has been out there for a while, and of course, there's been no objection or response filed by complainant. So I believe the commission can take that at face value that there is an agreement. So the proposed order that I have drafted would find that the complaint has been satisfied as per the specific provision of our rules of procedure. And it would go on to say that pursuant to that rule, the commission, upon finding that the complaint has been satisfied as far as the complainant is concerned, now considers whether the proceedings should continue to address any issues raised in the complaint that involve a general matter of public interest. And that's specifically provided in section 12215D. It says that, after there's been settlement or satisfaction among the parties, the commission should consider whether there are any general matters of public interest that are not resolved by the satisfaction or by the settlement. The proposed order would find that the issues raised in the complaint do raise general matters of public interest, but no further proceedings are needed to address the matters of public interest. The proposed order would find that the agreement reached by the parties addresses the public interest by correcting the notices issued by the defendants. The order would also find that the defendants' notices indeed violate the June 15th order in the manner described in the complaint. And the proposed order includes a footnote at that point that reads like this: the commission does not address REIA's claims that the defendants violated commission rules and FERC regulations, as the satisfaction of this complaint has rendered any decisions on those claims unnecessary to the outcome of this matter. The commission does address the defendants' violation of the June 15th order to clarify the scope of the June 15th order. The proposed order would conclude that the revised language of the agreed upon notices is consistent with the requirements of the June 15th order, while also providing more guidance to applicants and potential applicants. Now, the reason that my proposed order would not reach the issues of violations of FERC or commission rules is that, as I said, satisfaction or settlement means that the commission does not need to reach those issues. But I think the commission should go ahead and state whether there's a violation of the June 15th order, because that is an order of the commission. And this is an opportunity where I think the commission would want to clarify that the scope of that order, because it's the commission's own order. I think it makes sense there. The proposed order would dismiss the complaint as satisfied, and it would also incorporate into the order the agreement that the defendants made with regard to correcting the notices. In other words, the defendants agreed with, as a part of the satisfaction, that they would make these corrections to the notices and provide that notice to all those applicants to whom all the people to whom they had already provided the current notice, and also on their websites. But the order would also incorporate those promises as not just promises from the companies, the IOUs to REIA, but as orders of the commission. That, in other words, yes, please do that. Not just as part of the agreement, but we're ordering you to do that as part of this order to amend the notices and publish them. That provision of the proposed order is based upon the public's interest in being accurately notified regarding the status of these applications. As I said, this complaint goes beyond private interests of REIA. It goes to the interests of all applicants and potential applicants. So with that, I'll take any questions.
Commissioners?
Mr. Chairman?
Yes, Commissioner Masters.
Russell, thanks for that explanation. Before we issued after we issued the June 15th order, I had heard that not all of the investor-owned utilities were in violation of the June 15th order. And I know this, the action taken is to all investor-owned utilities. So did staff indeed find that all three investor-owned utilities had statements on their websites that was in violation of the June 15th order?
Yes, Commissioner Maestas, yes. They didn't find the thing is, staff's report didn't find them in violation. Staff didn't seem to have a problem with extra language in the notices, but they did find that all three of the investor-owned utilities had included that additional language, and that's why REIA points specifically to the collective form of notice that staff provides in their staff report, because that reflects either with exactly the language exactly or in substance what all three IOUs had provided in their current notices.
Okay, thank you. That's all I had, Mr. Chair.
Other commissioner comments?
Mr. Chair,
Commissioner Hall.
I'd just like to ask Russell to maybe clarify or elaborate, maybe clarify is a better word, his response to Commissioner Maestas there. Because this order doesn't mention anything about non-compliance by utilities on their websites. But Russell, can you just explain to me, did you say staff did look at the language on the website and determine that there was no violation of the order, I guess? I'm just confused with what you said there, but the language I believe we have in the order just seems pretty straightforward. It doesn't address any extraneous activity of the other utilities. So does that mean since you say staff looked at that and made a determination of some sort, should that be included in the order or not?
Commissioner Hall, in the docket 21112, the community solar docket, as part of the order, the June 15th order, the commission ordered staff to work with the three investor-owned utilities on the form of their notice and on how to provide that notice to current, prospective, and future applicants. And the order didn't require staff to file anything in that docket at all, following up on what they had done, but staff went ahead and did so. And I'm going to open the staff's report just to make sure I get this exactly right, because this is a very important point. Exactly what did staff say, and I just want to make sure that I get that 100% right here. Staff. So, and in that docket 21112, staff filed a report on July 14th, which is about 1 month after the commission issued its order requiring the notice by the utilities. And in that report, staff stated that it communicated with representatives of the investor-owned utilities and verified that each of the utilities had issued the notice. This is how I'm reading right from the report. By posting on their respective websites, staff also conferred with representatives of the utilities that distributed via email, et cetera. Let me get to the more salient points here. So this is, I'm sorry, you pass the point about how it was served, but okay. Additionally, so I'm reading from the report again. Additionally, so as to reach a broader potential audience and ensure delivery to as many likely applicants as possible, staff undertook the following measures to provide further dissemination of information contained in the notice. And the first thing, this is in staff's report, a generalized form of the notice as seen as in Exhibit A, that's Exhibit A to the staff report, that did not specifically reference an individual utility has been posted to the PRC's website NMPRC.org. And that Exhibit A is what is being quoted from by REIA. And it's unclear to me whether that collective form of notice was created by staff or was proposed by the utilities themselves, but it's one that's posted by staff on the commission's website. And so implicitly, I would say it's staff approve this language, and it includes the language to which REIA disapproves.
Hey, I get it. I think I understand what you're saying. The original notice language was objectionable. The utilities posted it on their website, and maybe that's what gives rise to the concern that Commissioner Maestas mentioned, because that would be the language in question. But now the issue has been satisfied and the language has been changed, right?
Yes. Well, it has been satisfied. It will be changed if the commission accepts this settlement that dismisses the complaint. Then the three IOUs will remove that. Now, I think, Commissioner Hall, maybe I'm anticipating what you're going to say. I did not include any in this order, any instruction to staff. I'm not sure. I looked on our website to see if there still is the notice with the language, the current language on our website. And maybe what you're getting to is we should include language in this instructing staff to remove that and post corrected notice. That might be something good to add here. I will know REIA asked, REIA no longer asked for this, but in their complaint, REIA asked the commission to order staff to withdraw the staff report, which is, I wouldn't recommend that. And it's not part of the satisfaction. It's not part of the settlement. REIA is not asking for that as a condition of settlement. So it's no longer something they're asking for. I would, just to clarify, I wouldn't advise the commission to ever ask staff to withdraw something that they filed, because staff is an independent party in these matters. But there could be a need here if that's notice is still on the website, or even if the notice is not still on the website, to post a corrected notice to our website, because that notice did include the language to which REIA objects. So if the commission wants to adopt this order, it probably would be a good idea. I should have thought of this, to include that an instruction to staff to remove that from the website and post a corrected notice. I don't know if I anticipated what you were going to say, Commissioner Hall, and I'm sorry to talk over you.
No, I didn't even notice that you did. Okay, so Mr. Chairman, I would move to approve the order. I move to approve the order. Well, let me see. I wonder if we need to include out language in the order instructing utilities and our staff to post the corrected language.
Well, the utilities are already agreeing to do that. The utilities are agreeing in the satisfaction to post the corrected language. But what I haven't included and possibly should include in this order is an instruction to our own staff to do that. Because, as I said, I don't know if the current notice is still on the website. I couldn't find it, but if anyone saw it on our website, perhaps it should be corrected with the revised notice on our own website as well. If that's what the commission would like to do.
Mr. Chairman, shall we inquire of whoever handles the website as to what is posted on it now, so as to not put the extra language in the order if it's not necessary? We could do that, I guess.
So Sarah, is that something you can quickly look up for us?
Sure.
So why don't you look that up, and in the meantime, are there comments from any other commissioners on this? Or questions? Okay. So Russell, this feels very consistent with our thoughts regarding the rules. You can't really fully consider the applications until you know the rules they're supposed to conform to. So any application submitted that's considering community solar would have to be regarded as incomplete at this stage. Is that correct?
Well, actually, Mr. Chairman, what I would say is the 2 points that were made in the notice very much still stand. And those are the points that, yes, the interconnection rules or the community solar rules are being formulated because there's such a comprehensive set of rules that will concern, the amount of megawatts that any one utility can have committed to community solar, and what the applications have to include, and so much that, yeah, it's any application right now with regard to community solar is almost certainly not going to meet all the possible rules and regulations that are applied, that are adopted by the commission, because it's going to be so detailed and complex. But I think the point that's being addressed here is that, but that's limited in the sense that there are other reasons to accept interconnection applications for these community solar programs, and the interconnection rules do not allow, as they are currently written, the commission or any utility to say, well, we're not going to accept that kind of community solar application, that kind of interconnection application, because it concerns community solar.
Right.
What this is saying is that they'll still accept those, but as per the notice that was provided, no community solar interconnection applicant can expect that will provide them any priority in terms of consideration by the utility of their program itself, because the utility will not only be considering interconnection, they'll be considering the community solar program itself as to whether it fits within the regulations to which the commission will be adopting, concerning the community solar programs. Do you see what I mean? I think what REA is saying, there are 2 different aspects here. There's interconnection, and then there's the community solar program. And what the notice was saying is our interconnection rules still remain in place. So to the extent that something is interconnection, no matter what it's for, the utility should accept it.
Yep.
But there'll be a separate kind of acceptance that has to happen for the community solar programs themselves, because they'll have a whole separate set of complex rules that apply to them. Does that make sense?
Yes. So at this point, did we have a motion? I can't recall now.
Yeah, I moved to adopt the order. And we were waiting to hear whether or not we've taken down the original language.
And I will second, and with the proviso that we can put in the amendment if it's necessary. We don't have to wait on Sarah.
I agree.
To get back.
Yeah.
And we'll do the amendment if the language is there on the website. If it's not on the website, then we're passing it without the amendment.
Chairman, I can make it easier. I can say that language would not need to be included in this order, because it could be an internal instruction of the commission to whoever's maintaining the website to switch that out on the website.
Let's just do it that way.
Just be to maintenance of the website. Oh, take that notice down, put this notice up.
Okay, so Mr. Chair, my motion is simply to adopt the order as written.
Okay, and I second. Any other commissioner comments?
Mr. Chairman?
Yes, go ahead.
Just a quick comment. I want to commend Russell. He was the author of the June 15th order. And obviously it's withstanding scrutiny and bringing order to the stampede of interconnection requests from solar developers. And prior to writing that order, I think we had heard that there was a misconception that if they're in an interconnection queue, they have some advantage in their community solar application. So I think here's an example where the PRC was proactive and responded to a situation that brought clarity and order to this current situation. So my hat's off to Russell and all of you, my colleagues, for adopting that order. That's all I had, Mr. Chair.
Thank you. And for solar developers, I want to emphasize that you're not being compared to cattle. We understand you and approve of your enthusiasm for this program. So thank you for all the applications. We just need to do this in an orderly way.
Mr. Chair.
Yes, Commissioner Hall.
Well, as much as I'd like to join with Commissioner Maestas in praising staff in any way, I thought the problem was that our original order, let's see, the original order stated that part of it's made, I think, was unobjectionable, that insofar as the no community solar rules currently in place, and there are no rules that authorize processing any community solar interconnection applications. That was correct, and that's still correct. But then subsequent language raised a question as to whether or not applications well, I guess it was an attempt to clarify that applications specific to community solar would not be processed. But I think the subsequent language is better because it simply says all applications for interconnection will be accepted and processed, but it doesn't give a project that may be intended to be a community solar project an advantage. And I think that's where we should be, pleased, because this language explains that all applications are on equal footing, essentially. And then once we get community solar rules in place, that may have consequences for community solar projects, but that they bear the risk for that. That's the part that's clarifying. So we were almost there with our first language, but I think it's much improved now. So I'm glad we have a good result.
Okay. With that, if there are no other comments, Michael, would you take the roll regarding the potential order?
Commissioner Vicente Aguilar,
Aye.
Commissioner Byrd, Commissioner Maestas,
Aye.
Commissioner Fishman,
Aye.
and Commissioner Hall.
Aye.
Commissioners, the order is approved by a vote of 5-0.
Okay, item number 8. It's been removed from the agenda. The next item is an executive closed session. So we've been going for an hour and 45 minutes. Folks, would you like to take a 20-minute break until 11:40 and then go into executive session?
How about maybe Mr. Chair, a shorter break, maybe 10 minutes and then.
Okay, we'll go
We can
to,
resume.
that's fine, 11:30. And we'll go into executive session. Isaac, are you gonna, or is it Sarah, are you gonna plug us straight into that?
Yes, I will.
Okay, thank you, Sarah. And you're relieved from your research duties.
Thank you.
Oh, okay, thank you, Sarah. Back in 10.
Mr. Chairman,
Yeah,
it's Michael Smith. If the commission, is the commission planning on coming back into open session and then going into closed session? Because it requires a vote.
oh, okay, let's take a vote on closed session real quickly here. First of all, do we have a motion
Move to go into closed session.
and a second?
Second.
we've got a second from, I think it was Commissioner Maestas.
Mhm.
And Mike, please call the roll.
Commissioner Berg,
Aye.
Commissioner Maestas,
Aye.
Commissioner Hall,
Aye.
Commissioner Fishman,
Aye.
Commissioner Vicente Aguilar. I can't tell. Is Commissioner Vicente Aguilar, are you still on?
She might be taking her break.
Yeah, I'm guessing.
Mr. Chairman, so the vote is 4-0 to go into the closed session. I just wanted to make sure, I guess, communicating with Isaac in terms of how this would take place, because I understand you, Isaac, would put us into a breakout room. Isaac, is that how this would take place?
Mike, this is Sarah, and I have been communicating with Isaac also, and I have a breakout room that's set up for you.
Okay, and so if the commissioners do not come back into open session, will they just be placed into the breakout room?
I can place them in the breakout room now and they can take their break.
Okay. And Commissioner Maestas, I believe, is in a public space. Commissioner Maestas, do you have the ability to either go to a more private spot or use a telephone or something of that nature to attend?
Well, there's no one in the room except my assistant, Christopher Hall, and he's going to step out. All the doors are closed. There's no one else in the hearing room. So I can just hear.
Okay, that's fine. I can't tell who else is there with you. So.
Okay, guys, let's take our break. Be back at 11:30.
Is there?
Okay. Are we all here back in open session?
3 of us.
Okay, we've got Commissioner Byrd,
Hearing room.
okay, Commissioner Hall, Commissioner Byrd, Commissioner Maestas, Commissioner Vicente Aguilar, you're back?
Here.
Terrific. Okay, so we're, do we need to vote to come back into open session? I'm always forgetting these procedures.
Mr. Chairman, yes, the commission would take a vote to go into open session and also recite that the only matters that were considered were deliberations by public body pursuant to section 1015.1, specifically regarding PRC docket 21-00083 UT. I think I just made that assertion for you, but.
Okay, yes, thank you. And so I will move that we go back into open session. Do we have a second?
Second.
Second from Commissioner Hall. And Mike, please take the roll.
Commissioner Maestas.
Aye.
Commissioner Vicente Aguilar.
Aye.
Commissioner Byrd.
Aye.
Commissioner Hall.
Aye.
Commissioner Fishman.
Aye.
Commissioners, the motion to go back into open session is approved by a vote of 5-0.
Okay, and with that, let's move on to our public deliberations on item 9, docket 21 83 UT in the matter of the application of Public Service Company of New Mexico for decertification and abandonment of 114 megawatts of leased Palo Verde nuclear generating station capacity and sale and transfer of related assets, and for approval to procure new resources under 17.9.551 NMAC. So Michael, please take us through this and the potential order.
Mr. Chairman, Commissioners, as you're aware, at the Commission's August 25th, 2021 meeting, the Commission issued an order on hearing examiner Glick's July 28th, 2021 recommended decision on the motions to dismiss concerning PNM's application. The matters that were not addressed by the Commission in that August 25th, 2021 order, which bifurcated the case and dismissed PNM's application for abandonment of the Palo Verde nuclear generating station leased capacity, were deferred for a subsequent ruling by the Commission. And that is the matters that we are addressing here today. Those are 3 PNM requests to approve regulatory assets. The order that I have prepared for you today proposes to find that the Commission, having considered the arguments presented in the exceptions and the responses to the exceptions, finds that the portion of the hearing examiner's July 28th, 2021 recommended decision addressing the motions to dismiss with prejudice PNM's request for a regulatory asset for the cost of obtaining an abandonment order is well taken and should be adopted, approved, and accepted as the Commission order of the Commission. With respect to PNM's requests for approval to create regulatory assets for rate-making purposes for the undepreciated costs of improvements made by PNM in Palo Verde Units 1 and 2, the Commission finds that these claims are most properly addressed in a full evidentiary hearing, together with the other issues remaining in this docket after the bifurcation of the replacement resource issues previously ordered. The Commission order then would provide that That portion of the hearing examiner's July 28th, 2021 recommended decision addressing the motions to dismiss with prejudice PNM's request for a regulatory asset for the cost of obtaining an abandonment order is well taken and approved and adopted and accepted as the order of the commission. PNM's request for approval to create regulatory assets for rate-making purposes for the undepreciated cost of improvements made by PNM and Palo Verde Units 1 and 2 shall be addressed in the evidentiary hearing together with the other issues remaining in this docket. C, this is the next paragraph. The parties shall address the issues raised in the recommended decision concerning the generally accepted accounting principle requirement that costs that a utility seeks to include in a regulatory asset must be unusual or infrequently occurring, how those terms should be construed, and whether the costs of undepreciated investments in generation plant being abandoned pursuant to the requirements of section 6216(1) et sec may satisfy the standard of being unusual or infrequently occurring costs. In addressing these issues, the parties should address what role a utility's participation in planning and promoting legislation that requires plant closures in advance of the expiration of an approved depreciation schedule should be considered, if at all, in whether an expense sought to be included in a regulatory asset may be considered to be unusual or infrequently occurring. In accordance with the recommended decision, the parties shall also address whether PNM is entitled to recover its undepreciated investments in light of the fact that PNM will no longer own the undepreciated investments. And then it provides that any other exceptions, pending motions, requests, or any other matter not expressly ruled on or addressed in the hearing or in the discussion of this order relating to the specific matters addressed herein are hereby deemed denied and disposed of consistent with the discussion of this order. And if there are questions, I can address that.
So commissioners, any questions, comments?
Mr. Chair, I have no questions, but I'd like to make a motion to approve the order as written.
Okay, we have a motion to approve. Do we have a second?
Second.
Second from Commissioner Maestas. If there's no further comment, Mike, please take the roll.
Commissioner Vicente Aguilar.
Aye.
Commissioner Maestas.
Aye.
Commissioner Byrd.
Aye.
Commissioner Hall.
Aye.
Commissioner Fishman.
Aye.
Commissioners, the proposed order is adopted by a vote of 5-0.
Okay. On to item 12, discussion items. Docket number 20-158. In the matter of an inquiry into potential amendments to NMPRC Rule 179572 NMAC relating to the renewable energy rate rider and line loss adjustments. And Judy, please.
Yes, good morning, Mr. Chair, members of the commission. This matter comes before you today on an update that Commissioner Fishman requested I provide to the commission about essentially the progress that we have made in docket 20-00158. I'll give you a little bit of background before I start the update. The background is that in a separate docket, case number 19-00296, in late April or May, we adopted amendments to the renewable energy rule 17.9.572 by final order. At that hearing and when the commission voted on the final order, there were several outstanding issues that the commission still wanted to investigate and possibly do further amendments to the rule, even though they were the commission was voting for a final rule because it had been like practically 2 years, and we wanted to get some rule in place. So we moved several issues into a docket that we had previously opened, which was 20-00158, which had another 2 outstanding issues that had been remaining from another docket, 19-00134, which was SPS's 2019 Renewable Portfolio Standard application case. So just to summarize, 00158 had 2 issues in it. And then when we did the final order in the Renewable Energy Act Amendment Rule, moved several other issues into this 20-00158. So where are we now in that docket? There's a small group that have been working on this rule with me, and it includes Robert Lundin and Commissioner Fishman. And after much discussion, there are like 3 areas that this group has, will be recommending be amended, which are whether the renewable portfolio standard rate rider should be eliminated, or if it isn't, should it be line loss adjusted? Generally, it's our opinion that we should be simplifying rate recovery and returning to just generally base rates plus the fuel clause, and try not to have so many rate riders. In the future, there will be a lot of rate riders with the electric vehicle rate rider, the grid modernization rate rider, the energy efficiency rate rider. Potentially half your bill could be rate riders. That being said, we do acknowledge that the utilities believe that the rate rider is a good use of a rate rider. So in the spirit of compromise, the proposal would be, and this is, just generally, that in the utilities next RPS case, they would file a plan for how to transition out of using the renewable portfolio standard rate rider in their next rate case. So a transition out of it is and they come up with a plan, and then in their next rate case, they would potentially eliminate the renewable rate rider and bring those costs back into base rates. The second issue that
Judy, could I just interject for a second here?
Certainly.
Yeah, just one of the issues that in terms of the renewable energy rate rider that kind of shows how out of whack or misleading it can be, is we approved just recently nearly a gigawatt of renewable energy with SPS between the Hale and Sagamore wind farms. And those are considered regular assets that are not at all considered in the renewable energy rate rider. And it's become so arbitrary about what's included in the rider and what's not, that we just question what it's really communicating to anybody. So that's kind of the basis for why we're feeling that, gee, this is something that we probably don't need in the future. So I just wanted to interject that.
Yes, and again, this is a proposal. it would be part of a notice of proposed rulemaking, and it would go through the entire process. The second issue was pertained to financial incentives, and that issue is hotly contested. In fact, it is the subject of a pending appeal now that SPS filed with the New Mexico Supreme Court, appealing the commission's final decision in case number 19-00296. That appeal, the briefing has been stayed by court order upon a request by the PRC and SPS to postpone the briefing until after SPS's pending renewable portfolio standard case is decided sometime before the end of the year. In that case, SPS is requesting a financial incentive. That being said, the issue that has been discussed in the case that I'm talking about now, 20-00158, the issue is, can the financial incentive be awarded for only reducing carbon even if the utility is not producing or acquiring renewable energy? And the consensus of the small working group was that it generally agreed with P&M's comments that the financial incentive must be used to incentivize producing or acquiring renewable energy, and not for other measures that don't involve producing or acquiring renewable energy, such as only reducing carbon. And in specific, P&M stated that in this docket that financial incentives under 6216-4D cannot be used to incentivize closure of a carbon dioxide emitting generating station such as Four Corners Power Plant, because the plain language of the statute provides that incentives are to, quote, encourage public utilities to acquire or to produce or acquire renewable energy, not to close carbon emitting generating facilities. So that's the second issue that the group would propose amending the rule to clarify. And lastly, the third issue was about defining average annualized, okay, this is a mouthful, defining average annual levelized cost and include a formula for calculating it. SPS suggested a formula, and it's mathematical, but let it suffice that the group recommends adopting that formula. There are other issues that the group decided did not need to be amended at this time, and I can go through them or not, it at the pleasure of the commission. So for now, I will stop and open it up for discussion.
So commissioners, thoughts, comments? We're a quiet group today.
Mr. Chair.
Yeah, go ahead. Commissioner
I guess I'll
Madden.
just make a general comment. I think it would have been good maybe to have just a memo just to give us some context on this, unless there was a late memo that was sent by email that I didn't receive on the subject.
Okay.
Yes, I understand, Commissioner Maestas. Commissioner Fishman, asked me to present an update, and I can prepare a memo for you. And I was actually planning on bringing the notice of proposed rulemaking with the memo that would describe this. I can bring it next week or the following week, whenever the commission wants it.
That would
Sounds
be
good to
great.
me.
Yeah.
Just by way of a little more background, there were probably 6 or 7 other issues that were kind of thrown into this bucket under this docket, that when we looked at it more closely with Robert and Judy, it just seemed clear there was no urgency, and we really needed more experience and information before we started messing with what already existed in the rule. So we kind of took a course where we're trying to focus on core issues that need some deciding. And frankly, the third issue, the average annual levelized cost, looks to be pretty straightforward. The first 2 issues, there's obviously some utility pushback, and we're going to need to spend a little time talking more about them and being sure we've looked at them from all perspectives. So just to give you a sense of the status, we're trying to keep it simple. Okay, if there are no further comments, let's move on to item 3. Whoops, this says discussion and potential action. I don't believe we have anything further on this particular case, 158 UT. So with everyone's permission, I'll move on to item number 11. In the matter of at 21 98 UT, in the matter of applications for the 2022 broadband program support from the State Rural Universal Service Fund, as per 1711-1031 NMAC. And we have Russell and Eugene. Please take us through it.
Good afternoon, Mr. Chairman, Commissioners. I'm just going to give a very brief presentation, a very brief introduction before handing it over to Eugene, who is giving the real presentation today. Just as a reminder, as I said in the memo, under the Commission's rules, the Commission is to make a decision on the applications that Eugene will be presenting on or before October 15th. But as I said in my memo, there are a couple of outstanding dockets that will almost certainly influence the Commission's decision, in the sense that they will inform the decision as to how much is available within the State Rural Universal Service Fund, the SRUSF, for broadband applications. One of those, with regard to setting a benchmark rates, will probably be determined by the end of this month. But the other one is the Sacred Wind petition, and due to the timing of the filing of the petition, there will probably be uncertainty as to the amount of that payment. That's in docket 21-193 UT, pretty late into November. So that's not something we have to deal with today, but that's just why at this point I can't give the Commission a dollar amount as to how much will be available for these applications. That's something that will be worked out in the near future. With that, also, Eugene will be presenting his short form presentation, and that's something that was provided with the e-agenda, along with other documents that were created by Eugene, including the 2 spreadsheets and his glossary of technical terms. And what else I have to say? Oh, I do have I have thumb drives available that were put together by Eugene, which include the applications themselves, if any commissioner wants those. So just to remind you of all that. And with that, unless the Commission has any questions for me, I'll go ahead and turn it over to Eugene to make the presentation.
Well, thank you, Russell, and good afternoon, Commission. And let's see how we can start this now. Chairman.
Eugene, can you increase your volume on your on your computer, wherever you are? You're coming in
Can you hear me now?
much better, yeah.
Okay. Again, good afternoon, Chairman Fishman and commissioners and the commission. This matter comes upon the commission as a staff report on the proceedings for filing and consideration of application for the 2021 broadband program support. I would like to first start, I think Mr. Fitz had indicated a little portion of that, and that is there is a informational flash drive that should have been delivered or can be available for each commissioner, which has roughly about 6 items inside of it, informational wise. That is 2 spreadsheets. One is a kind of more of an informational concerning the details of each and every one of the applicants, as well as their projects and funds, monies and stuff of that nature. And
Eugene, I'm sorry to interrupt you, but you're getting a little faint again. Is it just a matter of sitting closer to your computer or something?
hold on 1 second here, Commissioner Hall. See if I can increase this here. Okay, can you hear me now?
Yeah, that's great.
All right. As I said, the second spreadsheet is a criteria spreadsheet, which is more of an interactive spreadsheet that was being utilized for the commissioners concerning the selection process. That would make it much easier for you commissioners to basically add or subtract and make your selections monetarily or just with the aspects of the companies and their projects. You do have a glossary on definition just for the information concerning terms and acronyms and just a little bit more of a background technically that I added there too that could be very helpful for you guys. As Russell indicated that my presentation is the short presentation, which is for time limits. I introduced a second, a short and a long. The long presentation is more informational, is more in detail that you guys will have as well on each applicant as well as each job. A lot more information upon what I'm about to deliver today. And of course, you have all the information submitted, by the applicants for this year for the grants. So if to start it, let's get started. Now, according to the State Rural University Service Fund and Broadband Program 17.11.10.31G, subset 3, staff is required on or before September the 1st to make a presentation to the commission with an analysis of the application for awards. This presentation fulfills staff's requirements under that provision of 17.11.10.31 NMAC. There are a total of 15 applicants with a combined total of 56 proposed projects. The total cost of these 56 proposed projects is estimated at $49,832,579.23, with a total amount of monies requested from the broadband program of $37,020,771.12. Now, the applicants combined with contribution matching funds in a total amount of $12,798,909.15. And on December the 7th, a little history, December the 7th, 2017, the commission issued a final order in case number 17-00077-UT, which repealed and replaced the RS-USF rule with an amended version. Among the amendments to the the SR-USF fund were amendments to the broadband program provision under the 17.11.10.31 NMAC. The amended RS-USF rule include the following provision. On or before May 1st of each year, the commission shall open a proceeding and establish a 30-day window for filing applications for broadband program support for the following calendar year. Whereas the commission staff or third-party contractor shall review all timely applications pursuant to 17.11.10.31G, subset 1, NMAC. For purpose of administrating the broadband program, the commission may find that a broadband program proposed project area in a rural area, notwithstanding the definition of rural area in subsection R of 17.11.10.7 NMAC, if determined that 1, the area otherwise has the characteristics of a rural area. 2, the area is unserved or underserved by broadband. And 3, the public interest requires that the area be classified as rural. The commission on May 1st, 2021 issued an order opening proceeding for filing and consideration of application for the 2021 broadband program support to all interested eligible telecommunication carriers, or ETCs, in the state of New Mexico. On June 1st, 2021, Smith Bagley Incorporated, also does business as Cellular One of Northeast Arizona, CenturyLink, Eastern New Mexico Rural Telephone Cooperative, also known as ENMR, Plateau Telecommunications, Inc., Valor Telecommunication of Texas, LLC, also does business as Windstream Communications Southwest, Baca Valley Telephone Company, Inc., Sierra Communication, Inc., Continental Divide Electrical Cooperative, OSO Internet Solutions, LLC, NTUA Wireless, LLC, ComNet Wireless, LLC, Penasco Valley Telephone Cooperative, Dell Telephone Cooperative, Inc., Roosevelt County Rural Telephone Cooperative, Inc., and Tularosa Communication, Inc., respectively filed broadband funds applications to qualify for the 2021 broadband program support grant. Now, the staff review in this process is that the staff of the Commission Telecommunication Bureau have reviewed all parties and information regarding their broadband fund applications for consideration for the 2021 broadband program support grant. In this report, staff will briefly explain and discuss the contents of the various projects proposal in the following order, respectively. Smith Bagley, Inc., Valor Telecommunication of Texas, or Windstream Communication Southwest, CenturyLink, Plateau Telecommunication, Eastern New Mexico Rural Telephone Cooperative, Baca Valley Telephone Company, Inc., Sierra Communication, Continental Divide Electrical Co-op, OSO Internet Solutions, NTUA Wireless, ComNet Wireless, Penasco Valley Telephone Cooperative, Dell Telephone Cooperative, Inc., Roosevelt County Rural Telephone Cooperative, Inc., and Tularosa Communication, Inc. First, the broadband fund application was structured to emphasize every applicant proposed project in its most relevant detail and have applicants submit these details together in forms of an attachments. Now, the attachments are such as Attachment A, which is list of all address, total population, resident and business, the cooperation area, affected funds and requested. Attachment B is project budgets. Attachment C is the network or system diagram, the services provided. Attachment D is the design plans and documentation. Attachment E is the project plans, project implementation plans. Attachment F is an operational plans, providers information. Attachment G is an area map and or a GIS shape files. Attachment H is letter of support. Attachment I is commitment from the community anchor institutions or public safety networks. And attachment J is all additional documentation or information relevant to the project. Secondly, staff utilized the available resources in regards to the New Mexico Department of Information Technology interactive web broadband map and Earth Data Analysis Center, also known as EDAC, data respectively to assist with the verification process of the applicant's submitted propagations, geomaps, and cartographic boundary shapefiles. Third, staff maintain an open channel of communication with each applicant to assure the accuracy of their submitted applications. In addition, staff has constructed a digital, as I said earlier, spreadsheet to help emphasize for the commission the various projects proposals and site location for each applicant. This included an interactive cost estimate tab to further assist the commission during this process. Now, this process allows staff to evaluate adhering to the compliance criteria established in 1711.10.31 NMAC, each proposal separately, and construct a comprehensive report on every proposed project submitted by all the applicants. Now, after reviewing all the information submitted by staff by the applicants, staff believe that the companies have satisfactorily answered all of staff inquiries and all the project proposed submitted by the applicants are accepted for consideration to move forward through the selection process by the commission. And finally, this process allows staff to analyze each proposal separately and construct a comprehensive report on each of the applicant proposed broadband projects that are eligible for the grant. It also allows staff to evaluate the applications in compliance with the criteria outlined in 17.11.10.31 NMAC. At this point, I'm going to read out the applicants and their proposals. First, Smith Bagley Incorporation, also do business as Cellular One of Northeast Arizona. Smith Bagley proposed 20 projects that consist of 6 LTE overlays, 9 new tower builds, and 5 fiber optic build-outs that would provide access to cellular voice services and or mobile 4G LET broadband data service to customers that are
Eugene?
currently yes.
Yeah, excuse me. Is there a way you can post this on the screen?
I shall try. Let's see.
For some reason on my other computer, I can't seem to call up the attachments to the agenda, so it's.
Let's see if I can pull. Can you see it?
Yes, thank you.
Okay. So let me move this over. Okay. As I said, 9 new tower builds and 5 fiber optic build-outs that would provide access to cellular voice services and or mobile 4G LEE broadband data service to customers that are currently unserved or underserved in the unincorporated areas of McKinley and San Juan counties, respectively. Smith Bagley Inc. wireless network transport both voice and data traffic from each cell site to cellular towers back to a mobile switching center, or MSC. The mobile switching center houses core components to process voice calls, text messages, or SMS, or multimedia messaging services, such as pictures, messaging, and data. Voice and text, 3G or 4G LET technologies that originate and terminate users within the Smith Bagley Inc. network are routed and connected with a MSC voice and text originated or terminated outside the Smith Bagley Inc. network is routed by the Mobile Switching Center, MSC, to interface with the public switch telephone network. In this project, the existing 3G technology will continue to provide voice and text. Now, data session or requests, 3G and 4G LTE technologies are transported from all the cell sites through the mobile switching center to the internet and back to the user. In addition to the cellular voice service, key to improve public safety and emergency services, mobile broadband 4G and LTE increasing the mobile data broadband speeds for 25 megabits per second download and 3 megabits per second upload. As I said, the total proposed project for the 20 new projects is $10,519,000. The amount of the grant fund requested is $7,428,989.00. The amount of the matching fund, which is 25%, is $2,571,530.00. And moving on to ballot. Now, keep in mind, I know there's going to be several acronyms here and a lot of terms here. That's the reason why I included the glossary there to give you a little bit more background for any commission that may need it at this point. Valid Communication of Texas, LLC, also does business as Windstream Communication Southwest, or Windstream. Now, Windstream proposed 7 projects that would expand its delivery of wireline broadband service to their Albuquerque, Capitan, Charma, Hayman Spring, Lovington, Tierra Maria, and Truth or Consequences unserved and underserved exchange areas. Windstream will provide Ethernet service over their existing central office fiber connected multi-service access nodes that house optical line terminals, OLTs, equipment in support of its passive optical network outside plant's fiber network. Now, utilizing multi-port service terminal and optical network terminal for the fiber drop to their customer premise, the proposed project will support broadband internet access service of speeds of 1 gigabit symmetrically and voice grade service to all households and business in their proposed project areas. Now, the total proposed cost for the 7 projects is $6,479,836.00. The amount of grant funds requested is $4,859,876.00. And the amount of the matching 25% that they will do is $1,619,959.00. Next, there's CenturyLink. And CenturyLink proposed 1 project that would expand its infrastructure deployment of voice and broadband service to unserved and or underserved rural areas of its Socorro exchange. Now, CenturyLink will be using a gigabyte passive optical network technology that will place fiber to each of the property lines of the living unit. A fiber distribution hub equipped with 1x22 passive optical splitters that will be strategically placed in each serving area. A mix of burial and aerial feeder fiber will be extended from the central office building to each fiber distribution hub. Now, the mix of burial and aerial distribution fiber will be extended from each of the property lines of all homes within the designated area of the build. When the customer requests the fiber to the home service, a fiber service drop will be placed to the home and the optical network terminal equipment will be installed. Now, within the central office will house a host digital terminal / optical line terminal bay that will provide the ports required to feed the splitters and place at the fiber distribution hub locations. Now, the optical network terminal will have 2 10 gigabits Ethernet uplink switches to the data network. Now, the uplinks are proactively monitored and can be augmented with additional 10 gigabits Ethernet switches based on this network utilization threshold triggers. Now, the total proposed cost for the Socorro Exchange project is $1,348,166. The amount of the grant fund requested is $1,011,124.50. And the amount of the matching fund, 25%, is $337,000 $41.50. Next is Plateau Telecommunication.
Eugene, this is Steve here. Sorry to
Yes, that's
interrupt you
okay.
again. I'd received a note from the mayor of Socorro, and I passed it on, I believe, to you and to Russell both. And the mayor of Socorro was saying that the city was entering into a contract with another provider that they felt would cover or be to some extent duplicative of the proposed CenturyLink project in Socorro. And I was wondering if you'd had any chance to follow up on that and what the status is there.
Quite frankly, I am aware of it. I haven't had much time to follow up on the reasonings behind it. And it is within now the process selection of the commission and you commissioners. And at this point, I don't know if there's much more unless you suggest somewhere to, because I don't think there's a conflict. There is a request for one company from another, I am assuming at this point. And that may be maybe in the commissioner's hands at this point. You know, I'm here to give you the information upon it to see, at least give you the option of what was submitted compared to what was at this point.
Well,
I do believe they have a complaint section.
Yeah, I think what I need here is I'd like the Telecommunications Bureau to follow up with the city of Socorro and get us some details and give us its recommendation of whether the CenturyLink project in Socorro will be helpful or will just duplicate what the city's already got underway. And so if the Telecommunications Bureau could follow up on that, I know the mayor there will be very open to connecting you with whoever you might need to talk to. But I'd very much appreciate that bit of research so we can decide on that particular item.
Chairman Fishman, commissioners, I can definitely do that. I will follow up the information upon getting in contact with the mayor and see what the address and get the information upon that and get it back to you, commissioners. So
terrific. Ravi's a terrific guy over there, so I'm sure he'll connect you everywhere you need to be connected.
Okay, I will get that information from you guys on a sidebar, and so I can move on forward with that.
Okay, thank you.
Oh, you're welcome. All right, let's move on. Plateau Communication, Inc. Plateau proposed two projects that would provide access to voice and broadband service to customers that are currently unserved or underserved in its service territories of East Clovis and Curry County Buffalo Road service area. Now, Clovis service areas between spaces that have access in gigabit broadband service from Plateau. Plateau was built fiber in the urban area of Clovis, which has sufficient density to financially justify the construction of the fiber to the home premise, I should say, network. Now, Eastern New Mexico Rural Telephone Cooperative, Inc. is the parent company of Plateau Telecommunication. It has built fiber to their incumbent local exchange customers surrounding the proposed service area of East Clovis. Therefore, these customers are in the often described donut area between areas that have access to fiber to the premise-based broadband service. Now, the access network would be a fiber to the premise network using standard active Ethernet technology with a dedicated fiber optic network terminal to each customer's home. And spare fibers optic strands would be designed to accommodate growth in the area. The network will use an advanced dense wavelength division multiplexing and multi-protocol labeling switching transport network to provide bandwidth on the core network. The network will provide 3 broadband rates, which is 100 megabits per second symmetrically, 500 megabits per second also symmetrically, and 1 gigabit per second also symmetrically. The total proposed cost for the 2 projects is $628,153.09. The amount of grant fund requested is $471,114.79, and the amount of matching fund is 25% is $157,038.30. Forgive me, there's a lot of numbers that I've been doing forever. $157,038.30 is the 25%. Moving on. Eastern New Mexico Rural Telephone Cooperative. Now, Eastern New Mexico Rural Telephone Cooperative Inc. proposed 1 project that will provide access to voice and broadband services to customers that are currently unserved or underserved in its service territory or is Termentina, New Mexico. Now, Eastern New Mexico Rural.
Mr. Evans.
Yes, Commissioner Byrd.
Just yes, thanks. Just curious. Not sure where Termentina is, but is that Trementina?
Termentina.
Trementina. I think it's spelled wrong. There could be a town that named that, but there is a Trementina, New Mexico.
Okay, what that was given to me. So if that is incorrect, I'll look at that and make a correction.
Okay, I'm just curious. Not saying there isn't another place. I know there's a Trementina.
That's very possible. That was Commissioner Byrd. That's what was given to me through NMR. So unless that is a misprint of my part, no, I apologize. However, I'll make sure that is correct. Moving along, the total proposed cost for the project is $2,872,788.88. The amount of grant fund requested is $2,154,591.67. And the amount of the matching 25% is $718,197.21. Next, Baca Valley Telephone Company, Inc. Now, Baca Valley Telephone Company proposed 2 projects that would provide access to voice and broadband service to customers that are currently unserved or underserved in its service territories of Johnson Mesa and Kennedy Road. Now, Baca Valley Telephone Company, Inc. deployed all standardized Calix network equipment such as Calix GE-24E7 blades and chassis that deliver high-density point-to-point Ethernet or active Ethernet service, and standardized Calix 711 ONT at the customer premise, plus offer customer Calix router units for rental. Now, the optical network terminal have 2 dial tone ports and Ethernet and 2 Ethernet ports. Again, just want to remind you, my glossary. The total proposed cost for the 2 projects is $661,834.11. The total amount of the grant fund requested is $441,834.11. And the amount of the matching fund, 25%, is $220,000 straight dollars. Moving on, the Continental Divide Electric Cooperative, Inc. Now, Continental Divide Electric Co-op Inc. proposed 2 projects that will provide access to voice and broadband service to customers that are currently unserved or underserved in the service territories of Grant and Milan. Now, this project proposed to extend the Continental Divide Electrical Cooperative fiber backbone and fiber to the home service, which is FTTH, to Grants and Milan service areas by constructing last mile fiber and drops from the backbone built to serve the Milan and Grants area. The project shall provide last mile service, which is defined as the portion of broadband service that deliver an internet connection to an end unit user that lacks access to a voice or broadband service at measurable speed of 10/1 megabits per second or greater for unserved areas of 25.3 megabits per second or greater for underserved served areas. Now, Continental Divide Electrical Co-op proposed a gigabit passive optical network fiber to the home network. The fiber optic backhaul links would be configured using a 10 gigabit per second internet protocol IP. This phase is part of a larger 4-phase approach to build a fiber ring connecting all Continental Divide electrical substations in New Mexico. Continental Divide Electric will be offering voice over IP service to residential and commercial accounts, along with broadband starting at 25 megabits per second up to 1 gigabits per second. Now that's up and down downloads. Now the proposed cost for the Grant Milan Fiber project is $8,823,272.27. Now the matching of the grant funds requested is $6,617,454.20. And the amount of the matching fund of 25% is $2,205,818.07. Next is also Internet Solution. Also Internet Solution LLC proposed 3 projects that would provide access to voice and broadband service to customers that are currently unserved or underserved in its territories of Pine Meadow Ranches, Rama Navajo Chapter, and Rama Community. Also, Internet Solution has determined that a fiber extension to a tower located within the proposed service area with a robust fixed wireless point to a multi-point network utilizing a Cameron 450 point to the multi-point product lines for the best solution to reach the identified unserved and underserved locations. Now, also Internet will also install a 48-strand fiber within a single interduct tube located at the intersection of BIA 125 and BIA 122 to a proposed tower location. Now, this equipment will allow also the internet to offer speeds more than the current 25 megabits up to 100 megabits per second. Now, the total proposed cost for the 3 projects is $2,696,990.49. The amount of the grant fund requested is $2,022,742.87. And the amount of the matching 25% is $674,247.61. Next is the Navajo Tribal Utility Authority Wireless LLC, or NTUAW. The Navajo Tribal Utility Authority Wireless LLC proposed 4 projects that would provide access to voice and broadband services to customers that are currently unserved or underserved in the service territory of Newcomb, Nashati, Thurlow, and Baca Privet, forgive me, broadband service area. Navajo Tribal Utility Authority Wireless LLC is proposed to provide both mobile wireless broadband service and fixed wireless broadband services. NTUAW proposed that wireless technology would be the most efficient technology for the area, given the low density and geographic isolation of the area. The Navajo Tribal Unit Authority Wireless LLC proposed to provide last mile voice and broadband service utilizing 3G and 4G cellular technology and wireless internet service provider, or WISP technology. Navajo Tribal Utility Authority Wireless LLC will provide voice service utilizing UMTS, which is referred to as Universal Mobile Telecommunication Service technology, and the broadband service utilizing 4G LTE-TDD radio access network, RAN, and LTE TDD WISP service to in-unit user customers. Navajo Tribal Unity Authority Wireless LLC will utilize the PCS spectrum in the 1900 megahertz band to provide voice service. The Navajo Tribal Unity Authority Wireless LLC will utilize spectrum in the 600 megahertz band in combination with the CBRS spectrum over the 3.5 gigahertz band to provide broadband service. Now, Navajo Tribal Unity Authority Wireless intends to use a Radwin or similar off-the-shelf infrastructure equipment used by Navajo Tribal Unity Authority Wireless currently in the Navajo Nation. Now, the total proposed cost for the 4 projects is $2,033,103.20. The amount of grant fund requested is $1,524,826.65. And the amount of the matching 25% is $508,275.56. Next is ComNet Wireless. ComNet Wireless LLC proposed 3 projects that would provide access to voice and broadband service to customers that are currently unserved or underserved in its service territories of Hernandez, La Mesilla, and Velarde. ComNet proposed to provide last mile voice and broadband service utilizing 3G/4G cellular technology and wireless internet provider or WISP technology. ComNet would deploy UMTS and LTE TDD RAN, which is Universal Mobile Telecommunications System, and long-term evolution, time division duplex, and radio access network, which is what those acronyms mean, technology over the tower. ComNet plans to utilize Nokia equipment. ComNet will utilize Citizen Broadband Radio Service, or CBRS, spectrum over a 3.5 gigahertz band to provide fixed wireless broadband services. Now, ComNet intends to use Radwin or similar off-the-shelf infrastructure equipment at the customer premise to deliver broadband service and providing speed of 25 megabits per second down and 3 megabits per second upload. The total cost, proposed cost for the 3 projects is $2,025,547.29. The amount of the grant fund requested is $1,519,180.72. And the amount of the matching 25% is $506,393.57. Next would be Peninsula Valley Telephone Cooperative, Inc. Peninsula Valley Telephone Cooperative, Inc. proposed 2 projects that would provide access to voice and broadband service to customers that are currently unserved or underserved in the service territory of Iron Gate and Ranch and Elk Springs. Now, infrastructure will include aerial fiber cables that will be wholly owned by Peninsula Valley Telephone Cooperative, Inc. The fiber optic cable will be attached to poles owned by Otero County Electric Cooperative under the guidelines of a joint use agreement. A portion of the proposed fiber optic cable will be placed in a vacant conduit that will previously installed with the copper facilities that serve the area. Now, access points will be placed at various locations to serve customers with an aerial fiber optic cable whenever possible. Varied service drops may be required at some locations. The proposed project area is currently unserved by broadband standards, although Peninsula Valley Telephone Cooperative, Inc. does provide voice service to these locations. Completion of the fiber project will allow for voice and fiber to the premise broadband service of 25 3 megabits per second or greater to each location within the project area. The proposed cost for the project is $829,221.00. The amount of the grant fund requested is $621,916.00. The amount of the matching fund, 25%, is $207,305.00. Next is Dell Telephone Cooperative, Inc. Now, Dell Telephone Cooperative, Inc. proposed a fixed wireless open platform communication project that will provide access to voice and broadband services to customers that are currently unserved or underserved in the service territory of Queens, New Mexico. Now, Queens, for which this fund's application is submitted, is located between Sitting Bull Falls is a series of waterfall located in a canyon in the Lincoln National Forest, southwest of the city of Carlsbad, New Mexico. Remote and far removed from civilization, it stands at the edge of the wilderness boundary. Dell Telephone Cooperative, Inc. is planning to install 2 towers within the Queen area and utilizing a license of 11 gigahertz radio for backhaul and installing multiple access points on the tower. Now, Dell Telephone Cooperative backbone consists of a fiber optic cable from the Dell City Central Office to the Queen Central Office and is scalable to increase both the number of members subscribers. Now, the open platform communication assumed the use of citizen band radio service spectrum for the fixed wireless access equipment. And the subscriber penetration rate for the subscriber capital expenditures is 100%. The core can handle multiple 10 gigabit links, and the scalability of the 25 megabits per second upload, 25 megabits per second download speeds symmetrically, and with the scalability to upgrade the service up to 100 gigabits linked network if necessary. The fiber middle mile network is part of the cooperative 1,000-mile fiber ring network, which provide high-speed digital connectivity to West Texas and southern New Mexico. Now, the total proposed cost for Queen's last mile upgrade and expansion project is $514,000, no 0 cent. The amount of the grant fund requested is $385,000 straight, no cent. And the amount of the matching fund would be $128,500 and $500 and 0 cent. And moving to Roosevelt County Rural Telephone Cooperative, Inc. Now, Roosevelt County Rural Telephone Cooperative, Inc. proposed a project that would provide access to voice and broadband service to customers that are currently unserved or underserved in the service territory of Elida West. The proposed network element to be funded under the application consists of 3 primary elements. Last mile fiber to be constructed from an existing electronic cabinet, which will pass 17 potential customers' location. Standard base active Ethernet optical line terminals, or OLT, equipment can be placed in an existing electronic cabinet to serve the customer's location. Active Ethernet optical network terminals equipment to be installed at each of the customer's location. The proposed network is capable of providing 1 gigabit per second broadband service to each customer's location. The optical transport network currently utilizes 10 gigabits per second link, which have equipment redundancy. Placement for the proposed last mile fiber will be in the existing right-of-way and on the existing pole line. Now, the applicant already has a pole attachment agreement in place with Roosevelt County Electric Co-op. Roosevelt County Rural Telephone Cooperative, Inc. will offer the following to every location in the proposed project: area speeds of 25 megabits per second to 100 megabits per second symmetrically. Now, the proposed cost for the project is $2,101,650, and the amount of the grant is requested is $1,576,238,000, and the amount of the matching fund is $525,412. Next is Tularosa Communication, Inc. Now, Tularosa Communication, Inc. proposed 4 projects that would provide access to voice and broadband service to customers that are currently unserved or underserved in the service territory of Bent, Dugan, La Luz Gate, and Sun Valley Water Sanitation. Tularosa Communication will install buried and aerial fiber cable throughout this project. The service drops that will be used will be the 4 fiber armor drop, dependent upon whether it is aerial or burial. Tularosa Communication, Inc. will use Cadillac 716 ONTs, and each service location will have the capability of the 2 dial tone and 4 Ethernet ports on its ONT. Now, Tularosa Communication Inc. will have 2 service speeds, respectively, at 100 megabits per second and 1 gigabit per second, symmetrically. Tularosa Communication Inc. will extend fiber across Highway 54 and Highway 70 with an electronic cabinet to serve customers in the project area. Physical diversity via fiber at the main central office in Tularosa, as well as central office in Carrizozo, Cloudcoff, High Road, and Alamogordo. The network capacity for the backhaul is 10 gigs with a future upgrade to a 100 gig capacity. The total proposed cost for the project is $6,780,683.81. The amount of the grant fund requested is $5,064,902.32. And the amount of the matching 25 is $1,702,088.353. Now that ends, and at this point, forgive me on spewing all that out in one time in aspect of mixing up the words, but at this point, I stand for any questions that the commission may have with me on this.
Commissioners?
Mr. Chairman, I have one question on this last project. They mentioned, Eugene mentioned that the fiber is going to extend across the highway with an electronics cabinet to serve. How is that done? Is it overhead, I guess, on what kind of poles? Just specifically fiber poles or what?
My understanding is that it could be in ground or aerial. But it will be going across the highway 54 and 70. So if my recognition of that area from being down there, I think it could be in ground, Commissioner Hall.
Okay. All right. Thank you very much.
You're welcome.
Okay. Other commissioners, questions for Eugene? Okay, Eugene, thank you very much. And what's the schedule for coming back for proposed approval?
Okay, according to
Eugene, I can, I'm sorry.
Oh,
I think the question was for me. I was just unmuting myself. I didn't mean to, sorry, Eugene. Mr. Chairman, Commissioners. So October 15th is the deadline under the rule, but as I said in my memo, the commission could vary from that and may need to, because as I said, there are 2 dockets outstanding that will affect how much is available for the broadband program. One of those dockets, which is the one concerning benchmark rates, the commission will be able to decide before by the end of this month. But the other docket is the Sacred Wind petition. And based on the timing of the filing of that petition, which was just, I think, a month and a half ago, that proceeding has to be completed within 120 days under the statute, which is a very short proceeding, and it's before Bob Lennon at this point. But that 120 days still is November 26th. So that will be on that. There will be some uncertainty as to that amount, unless it goes even faster than 4 months. And so we're going to have to, as I said in my memo, I haven't really figured out exactly how I'd like to deal with that part of it at this point. We could discuss that today. Like I said, I don't really have a solution. It's possible. I think we'll probably want it more than October 15th. And there's, bless you. There's some room in the schedule, for the commission to have more time, but that might not fix this problem with the Sacred Wind petition. That is, of course, a brand new amount to be determined under the legislation that was recently passed. So that does create some uncertainty there. As I said in my memo, the commission could decide to, issue a decision on these on the applications, while leaving just ample room for whatever that amount is for the Sacred Wind petition. I'm sure we'll have some kind of range at some point, but that would also mean the commission wouldn't be able to maximize the amount of applications granted this year, unless we do some sort of workaround where there's a conditional grant or something like that. There are ways I think we can work with it, but there will be uncertainty.
Okay.
Mr. Chair.
Yeah, Commissioner Hall.
Well, a couple of things. One is just what Russell just mentioned, something about a grant and a workaround. You mean in order to generate some more funding to cover more projects? Is that what you're talking about?
No, Commissioner Hall, talking about the $30 million cap, statutory cap, which we're stuck with. You know, that minus whatever the other obligations of the fund are, you know, determines what's available for the broadband program. And this year I said there's an uncertainty right now. Last year I was able to give you a number, 12.9 million or 13.9 million was what we had available. Right now there's uncertainty due to two outstanding dockets. One is the benchmark rate setting docket. As you recall, the commission is considering whether to leave the bench. Anyway, that can be decided by the end of this month because we're just waiting for some filings September 15th. And that way there'd be ample time. That will be a known number. But the Sacred Wind petition for support is an unknown number. It's under the new legislation that was just passed in this most recent legislative session. You know, there are some criteria for how we determine the amount, and that is currently pending before Bob Lennon. But it was recent. The petition wasn't filed all that long ago. I think it was about a month ago. We're supposed to have it done 120 days, which is a deadline of November 26th. But that's still November 26th. It's a bit, you know, it's a bit late. Yeah, it's a little bit late. Now, the October 15th deadline, as I said, which is a deadline given the rule for the commission to make a decision on the applications, that can be varied from and moved back a little bit. So, you know, I don't know, we might have to wait and see a little bit how that proceeding goes, and we don't.
So you're saying we don't really know how much money we'll have to stay below, right?
Right.
We don't really know.
Yeah, we'll have a better idea at the end, toward the end of this month or the beginning of next month, when the commission has made a decision, most likely on the benchmark rate case, but there will still be uncertainty about the Sacred Wind petition. I think I'm going to look at the FIR that was submitted. I mean, for one thing, we have to be careful, one, that the commission doesn't make any decisions that appear to create a prejudgment of a Sacred Wind petition, but we may have to use an estimate that was provided by staff during the legislative session with regard to the Sacred Wind bill as to what the amount of the payment might be, and, you know, leave room for that. That means you wouldn't be able to maximize the payments that you make under the broadband program because you'd be leaving ample room for an amount of payment to Sacred Wind that you don't know. So that's an issue there too. I'll take a look at the FIR. I'm not even going to say what I think it was because I may not remember it correctly. I'll send that FIR. That'll just give you, you know, an idea of what staff thought the payment range might be for the Sacred Wind petition.
Okay. Sounds like all we can do at this point. The other thing I was going to say, Mr. Chair, is that, you know, last time we applied some criteria that we identified, you know, just as a practical matter to be able to weed through and try to serve the public and, you know, all the interests that were involved. But, you know, especially we were trying to find projects that provided the most value for the dollar and that reached underserved folks. So, and I thought I saw in a memo, or maybe it was Russell's memo, that said that they'd sort of,
Yes,
there is a ranking, but we could apply. He suggested that I think it suggested that we use those criteria again. Can you want to speak to that, Russell?
Commissioner Hall, yes. In the memo, I didn't suggest what criteria to use. I believe our rule, I can't remember what our amended rule says as to the criteria. I'll take a look at that.
It didn't specify the criteria we used.
Yeah, I think the amended rule is pretty open right now, but I have to take a look at that.
Okay.
But what is mentioned in the memo is that staff created one of those two Excel spreadsheets that was provided with the E agenda did the prioritization that the commission did last year, which is unserved projects, prioritize projects that serve unserved areas, come before projects serving underserved areas. And within each of those categories, the projects that have the least cost per customer served are prioritized over others. They're prioritized in that order. So you
Yeah,
do
okay.
have that. And the commission did follow that as its criteria last year. But I
That's
think
right.
one exception, I think there was one of the projects within the unserved areas had a very, very high cost per customer. And I remember that the commission decided
Right. You
to
threw that
not
one.
include that one. So,
Yeah. So what I was going to say, Mr. Chair, is that I think we definitely have to look at the spreadsheet that Eugene gave us that has more of that information. I mean, this is useful to go over what the elements of the projects are and their costs, but we still have to look at that other information to be able to really parse through everything. So, and I think we can, do that on our own if we want to. I would hate to put Eugene through having to read all of that. That was a big spreadsheet. It's got a lot of information, but that's something I think that we could be doing in the meantime and at least give ourselves a, sort of a batched approach, to projects, at least, identify the ones that seem like the most needy and do a little bit of sorting like that anyhow, even though we don't have a hard dollar ceiling to work within.
So that spreadsheet was a great tool.
Chairman Fishman, if I may,
Oh, yeah, go ahead, Eugene.
just wanted to address Commissioner Hall.
Sure.
Yes, that is correct. Commissioner Hall, that's one of the reasons why I created the spreadsheet that is interactive, because as Russell indicated, I devised it in a dual way, whereas is unserved and then a project that is unserved and also the project that is underserved, but also with a from low to high when it comes down to the request of funds.
Right.
So that allows you to see the prioritize how the rules want to do it and how to make the selection, and also that you can select those particular projects, move it over to the right, and it will continue to add the amount. So you don't have to keep track of that; it will keep itself. And that spread from both the unserved and then it will bleed over to the underserved to get a bottom line figure if indeed there's some underserved.
I can't quite hear you here now. That brings.
I said, and that will, the adding process or subtracting process will bleed over from the underserved to the unserved to the underserved, so you can get a bottom line figure. So, and even the underserved is also created in a way where we have the lowest amount to the highest amount. So when you look at that spreadsheet, I did a lot of work on the spreadsheet. So when you look at the spreadsheet, you would notice that that is very helpful for you guys to kind of get that pretty much decided if you can.
Yeah, that's very, very much appreciated.
So Eugene,
yes,
for whatever reason, I just from my agenda, I cannot pull up these documents. So I'm wondering if you could resend that direct via email, at least to me.
Which document? I'm sorry.
Well, the spreadsheets.
Okay. Did you have the flash drive?
I've got a flash drive. Yeah.
Yeah. I gave distribute flash drive for each commissioner that have all the information, all of my presentation, as well as all the information on the spread drive. So you should have the flash drive.
Mr. Chairman, let me to explain.
Yeah, okay. I don't have go ahead.
Okay, what was attached to the agenda were 5 documents that concerned all the applications: the short form presentation, the long form presentation, both of the Excel spreadsheets, and the glossary. There were the rest of the thumb drive information consists of the actual applications themselves. I have, as I mentioned in the memo, I could send those by FedEx to the commissioners or by Dropbox. And I'm going to try to send them by Dropbox to Commissioner Byrd, who has requested them this afternoon. And if I'm able to do that, I'll just send it to all the commissioners. I just have to figure out if I can handle it through Dropbox with my connection and all that.
So it's the spreadsheets that for some reason I can't access today. And the thumb drive, if you're mailing those along, that's fine too.
Yeah, Mr. Chairman, I'll handle that. Eugene, Mr. Chair, I'll send those documents to you by email, and then I'll try to do Dropbox for the applications themselves.
And just to clarify, on the spreadsheet, does that include cost per new customer served?
Yes.
Yeah.
Perfect. Okay,
Yeah, Mr.
great.
Chairman, there are actually two spreadsheets. One does the prioritization that was done last year,
Right.
similar to the attachment to last year's final order. And the other is actually the more detailed informational spreadsheet that gives the 6 criteria that the commission looked at last year, including the customer service types of technology, et cetera. That's a separate Excel spreadsheet because that's part of the rule now, is that staff provides that as part of the presentation.
Okay, perfect. Thank you. Any other commissioner comments on this?
Mr. Chair,
Yes, Commissioner Mastis.
from the hearing room. So how much is available? How much is available?
Russell?
Well, Commissioner Myastis, as I said, there's some uncertainty as to that right now because there are 2 pending dockets that will determine how much is left within the $30 million cap on the fund. As you know, what's available for the broadband program is whatever is left over after the other legal statutory obligations of the fund are paid. Last year, that amount was $13.9 million. This year, I do not know exactly how much that will be, and for the reasons I've given. One is that there's a docket pending regarding the commission's consideration of possibly changing affordability benchmark rates, which will affect the amount of the payments to the rural ILECs for access reduction support payments. That will be determined, can be determined by the end of this month. We're just waiting for one more filing next week, and then I could bring that before the commission. So that answer, that amount can be plugged in to the equation by the end of the month. However, there was legislation passed this year regarding making a payment to Sacred Wind that would be similar to the rural ILEC payments. And there's currently the petition of Sacred Wind to determine the amount of those payments is pending before Bob Lennon, the hearing examiner. And the determination on that petition has to be made under the statute on or before November 26th. That's a little bit late, and because the commission's rule requires a decision on or before October 15th. That could be, that can be varied from and changed to a later date. But the commission may have to make a decision without knowing exactly the amount because of the Sacred Wind petition. There might be some uncertainty. I would say if at this point, and I will be, providing further information to the commissioners on this issue as things progress. It's possible that the amount will be, I don't think it will be very, very far from last year's amount of 13.9 million, because there may be, according to staff, there may be a decrease in $1 million. They anticipate about a decrease in $1 million in the amount of payments to the rural ILECs for access reduction support, based upon a sort of projected idea of what the access line counts may be, which is part of the formula for determining their payments under the statute. And this, I'm about to send to the commissioners. We don't know what the amount of the payment to Sacred Wind will be. That's part of like I said, a docket that the commission can't, opine upon until the record is closed, because that will be something the commission actually has to decide on or before November 26th. But I can give you a range of what staff said in their FIR to the legislature. It might be basically when the legislation was pending before the legislature. So that will give some idea. So we'll close in on the number. I don't think it'll be far from 13.9 million, but it could be 12.9. It could be 12. It could be, I don't know. It could be more if the benchmark. It could be more than 13.9 if the benchmark rates change, and there's a lot of moving parts. So unfortunately, I don't have a clear answer for you right now, as you can tell.
Roughly between 10 and 15 million, Russell.
I would say that that's a safe range. I think it should be definitely within that. I shouldn't say definitely, but most probably within that range.
Mr. Chair, I guess one last question on the criteria. We're carrying over this criteria that was adopted, I guess, by commission order. But now that NM Do It and the broadband office is going to play a more prominent role, do we have to submit this criteria for their blessing, for their approval before we apply it to rank these projects? Because that was my understanding, that now our project recommendations had to be vetted through the broadband office in New Mexico Department of Information Technology. So where does our criteria stand right now?
Commissioner Maestas has a very good point. The criteria that were adopted, that were used last year, they weren't really set as criteria to be used for all time. The commission did give itself room to, you know, and even the criteria, the commission even varied from those criteria in that order with regard to a particular project. With regard to coordinating on the two bills that were passed this year, I really don't have any updates since I sent an email to the commissioners this summer about that. There are two different bills. One is to create the Connect New Mexico Council, which will have a lot of very high level people. And the council, I don't think is even, I want to say is not even close to being created yet. They will define what digital equity and digital inclusiveness or inclusion are for which are criteria that will apply to us. But I think the council is even pretty far from being created. That's as far as I know. Staff had been contacted, and I've actually attended a meeting by Zoom a month or so ago with regard to the broadband office within NMDuit, and we are working with them. They actually asked us a lot of questions about how we do our process because they were impressed by our process for their own determinations. So we've notified them we're available to work with them and what our process is and what the rule is and what our procedure is. We will contact them to let them know where we stand. At this point, we're not getting any direction from, like I said, the Connect New Mexico Council, I don't think has even been formed. So I don't think we're going to get any direction from them this year, unless there's been recent news that I'm not aware of. But staff has been in contact with NMDuit about that particular bill, the broadband expansion bill. And we are working with them. We can let them know what we're doing. As I've said in my previous communications, the criteria that we use, I think, are congruent with what those entities would consider. I mean, if they give us more particular instructions in the future, then obviously we'll follow those. But at this point, I think what we're doing under our rule would not be contrary to their sort of general mandates, which is all we have to go with right now, because those two entities are just getting set up as far as I can see.
Mr. Chair, just a last comment on this. In looking at the total applications and the total grant funding requested relative to what we think we'll have available, I mean, we're looking at maybe cutting that by about $24-25 million. And so I don't know if there's a way in the future to maybe constrain the size of the applications to avoid such steep cuts. And then my other issue, and I hate to really, sound really parochial, but because we're going to have to cut so many project applications, we're going to have to rely on the historical criteria and the ranking process that's been carried over. But I would at least like to see where these projects fall by commission district. I know I sound like a dinosaur, but I'd at least like to know that as a matter of information, but perhaps not as a ranking criteria. Would that be possible?
Yes, Commissioner Maestas, that is possible. We can do that.
Thank you. That's all I had, Mr. Chair.
Okay. And just a little bit of history, Commissioner Maestas. In the past, we run into a situation where we didn't get enough applications to use the money. And there were all kinds of proposals of what we needed to do to stimulate more applications. One of them was give them 100% subsidy instead of a 75% subsidy. And we didn't do that, but we did make it clear we were open for more applications. And people have really responded with some good applications, which is great. I think I prefer our current situation to where we were, but certainly your thoughts have merit. We don't want people spinning their wheels on applications we can't fulfill. So somehow we got to find the balance. So
Mr.
just
Chair.
a little history. Yeah, go ahead.
On that point, Mr. Chair, I keep thinking that it would be really nice, as long as we're in this position and do it, and other agencies aren't in a position to be, doling out the funds that they will have in the future. It would be awfully nice if, especially this year, since we have such a influx of money from the severance taxes that are paid. It'd be really nice if we could get a legislative change that would allow our fund to be a little bigger, because it's just, there's obviously certainly a need to connect the rural areas of our state. And there's obviously a large number of projects that could be implemented. And the only thing that's limiting us is the size of our fund, because over half of it is used for other purposes. It's a puny amount of money for the amount of work that could be done. So I keep thinking we should maybe talk to the legislators we know, or who are on the appropriate interim committees, or go before some interim committees to see if something can be done, even if just for a year, until there's a better consolidation of broadband regulation in our state. And, specifically because we've gotten so many applications in. And I guess it's, I don't really know. I was about to say there's been a policy decision made, but there hasn't been a policy decision made to always use the best technology. But certainly rural areas, if they are to compete, will have to have really fast technology, which is usually fiber optic under the circumstances. But so it's costly. But I think we shouldn't just not try to ask for more money, given all these projects and the need for them to be deployed at this time.
So I think that's a really good point. And so Wayne, I assume Wayne's on because we're coming pretty close to his agenda item. We should start keeping a list of these legislative ideas. And I think some kind of temporary bump or a permanent bump to the RUSF is certainly worth asking about. And it's always a challenge in this kind of year, but it is a budget year and it's absolutely germane.
Yeah.
And, that's a good suggestion.
Of course, the problem is we have a deadline of divvying up all these, the funds that we have available to us by mid-October. And the legislative session doesn't begin until later. So,
well, Commissioner, go ahead.
Yes.
Yeah, we've done conditional orders in the past in these situations. Last year we had a condition, but of course it wasn't a condition that depended upon the legislature. We can do a conditional. It's possible maybe to do a conditional order based on what the legislature may do. Although I don't even know what amount they might consider to bump it up to. There's a big uncertainty, but we can. I think we can. We've been creative in the past. We can be more creative if we need to be. One thing I would note is, yes, commissioners, pursuing informal channels with the legislators might be a good idea for that. But there's also a report that we will be providing to the legislature by October 1st, which actually asks for the commission's input on the fund and the cap and such. And that docket has been open. We're just waiting for a staff's first draft of the report to consider for the commission's draft of the report, or the commission's eventual report. So on October, later this month, the commission will be adopting a report to the legislature, and that's a place where a formal recommendation could be made as well.
Great. That's great. I'm glad we can do that. I remember that from the past and I forgot it here, but that's another avenue. But I think we should do all the above to try to shake down some more money for this, because if we're going to do it, we should just do it,
Okay. Any other commissioner questions or thoughts? Okay, so let's move on to communications with Wayne, Chief of Staff, going into Wayne's world.
That's right.
Wayne's World.
Welcome to Wayne's World. Good afternoon, Mr. Chairman, members of the commission. I was taking notes on Commissioner Hall's suggestion, and we will follow up on that. I think this is as good a year as any to ask for additional resources, and you can't, it doesn't hurt to ask. So I will follow up. I need to obviously educate myself a little bit more on this, but once we've done that, we can come back to the commission with some suggestions. But I was taking notes, so thank you for that, Commissioner Hall. Mr. Chairman, I don't have a whole lot today. Sort of sound like a broken record, but the movers are back in the building today. If you hear any background noise, that's what it is. We've got a couple items we wanted to get out. We got some boxes that we needed to get up from the basement. And then tomorrow, hopefully, we're going to be going over to our 14 storage units that we are paying for and consolidate those down to hopefully no more than just a few. And that will be the end, at least for now, of moving into the building. But we are into our second week of being open to the public. Didn't have any, knock on wood, didn't have any hiccups the first week and haven't had any this week either. So that's good. Thank you to Commissioner Maestas for doing a test run in our hearing room. I wish I had thought about asking someone to come in and do that. That's a great idea. We'll learn from that. And when the commission or our hearing examiners decide to have hearings in the building, this will be very helpful. And also, Commissioner Maestas, I was taking notes on compliance. I haven't forgotten about that and giving staff a little bit of a break because, as the commission knows, we've had some large cases going on over the last couple of weeks, but we do have a meeting, a follow-up meeting on compliance scheduled for Monday afternoon, Commissioner, and we will report back to the commission, if not at next Wednesday's meeting, then certainly the Wednesday after that. And with that, Mr. Chairman, I don't know if I have anything else, but happy to answer any questions that commissioners might have or discuss any other items.
Commissioners.
Well, I just wondered if Wayne's managed to get the menus from the neighboring restaurants, for takeout, because there sure are a lot of them and they smell so good at lunch. So I think we're going to need that. But I can actually find my own, Wayne.
That's actually a good idea. I stopped at one yesterday, Mr. Chairman, Commissioner, that I hadn't been to. It's just right around the corner that I'd heard of, but hadn't been to. It was very good. And I did grab that menu. And the good news is that restaurants have had to adapt over the last year and a half, as we all have. And a lot of them are making pickup and delivery much easier than it might have been prior to the pandemic. So we'll be ready for you.
Do they have online orders?
They do. Yeah, you order it online and go there, and they've got a shelf, and your bag with whatever you ordered for lunch is right there. So it's easy.
Okay. Any other commissioner?
No.
Yes, Mr. Chairman.
Yes, go ahead. Commissioner Vicente Aguilar.
Yes, Mr. Chairman, I have some questions for the Chief of Staff. If he can go over how many employees he tends to move into the new building, which department is he concentrating on? If you can go over that, I would appreciate it.
Absolutely, Mr. Chairman and Commissioner Vicente Aguilar. And I'd be happy to send you a breakdown of the schedules that staff are on right now. We are continuing with a hybrid schedule, wherein staff are some in the building, some have a hybrid schedule where they're in the building a couple of days a week, but continuing to telework on the other days. And then we have some staff, particularly in our transportation division, that are continuing to telework entirely. I think this is an arrangement that we will be working under for some time. I think we all hope that we keep talking about getting back to normal. I think we all hope that we will at some point in time in the not too distant future be able to get back to a more normal situation. But Mr. Chairman and members of the commission, as you know, we don't have enough space for all of our current FTE in this office building, so a hybrid schedule is going to work well for us. We're trying to get some temporary workstations put up throughout the office. So for example, when commissioner assistants need to be in the office, we'll have an acceptable workspace for them. But, you know, again, having just been open for a couple of weeks, I think we're still kind of shaking out people's schedules, although everybody has submitted a schedule through their supervisor in terms of their telework and in-office schedule. So we do have that, and I'm happy to share. I don't have that for all of our 80-some employees, but I'd be happy to make that available to the commission.
Chief of Staff, do you have the hearing examiners? Are they working out of the new building, or how did you work that out?
Again, I believe, Mr. Chairman and members of the commission and Commissioner Vicente Aguilar, I don't have the schedules for all of them in front of me, but they all have submitted their schedules, whether it's in-office, teleworking, or a mixture of those two. I believe a majority of the hearing examiners are on a mixture of telework and in-office presence. We are, as I mentioned at the beginning of my report, still moving some furniture around. So I think that has inhibited the hearing examiners being able to utilize their office space. But it's my recollection that Ashley felt that most of the hearing examiners actually wanted to get back into the building on a more regular basis. So that's what I anticipate is going to happen.
Thank you very much.
Any other? Commissioner Byrd, any other comments?
No, sir.
Okay.
Thank you, Mr. Chairman.
Yeah, thank you. Let's move on to communications with General Counsel. Oh, and by the way, Wayne, before we go to General Counsel, Miguel found the last cushion to my chair. So thank you, Miguel.
Yes, he did. I don't know if he's on this call or not, but he did do an extensive search of those 14 storage units that I mentioned and discovered it in the back corner somewhere.
So anyway, that was great to see.
Yeah.
Communications with General Counsel.
I don't really have a lot to say today. I think Judy is over in the building right now from our office. I did actually notice a leather version of your chair, Commissioner Fishman, for sale on Craigslist. I was going to tell you about, but sounds like your chair's intact, so no need for that.
So what, were they asking, like $4,000 or what was it?
$20.
Oh, okay.
But that's it. We're just so you know, General Counsel's office, Russell, Judy, and I are going to be doing part-time availability over at the office. So we're sort of rotating. We're going to be rotating hours so that one of us is there probably at any given time.
Sounds good. I wanted to thank you, by the way, for your flexibility and the way you guys handled the agenda today with the presentations. So thank you, General Counsel.
Thank you.
Any commissioner questions? Communications with commissioners.
Mr. Chairman.
Mr. Chair. Oh.
I'm going to go with Commissioner Byrd first today.
Age before beauty.
Yeah, but you look a lot better though. You got your mask on, so.
Yeah, he's way back away from the camera, got a mask on. Thank you, Commissioner Maestas.
Yes, it's just been an easier meeting.
Anyway, I'll try to be quick. Update on the ambulance issues that we talked about a couple of weeks ago. It just so happens that my Senator Pat Woods is actually working on a bill dealing with this issue. And so he welcomed any input we could provide. I contacted Wayne and he talked to transportation. They've come up with a report, basically problems, I think anyway, problems they perceive and potential fixes for those problems. And we're going to meet, the staff and I are going to meet along with Chief of Staff tomorrow afternoon, talk about what they've come up with and move from there. Do you guys, I'll probably just send that out to each of my colleagues, let you guys review it, see if we have any questions, and won't use it as a time consumption item on the agenda.
Terrific. And we can always put it on the agenda if issues come up.
Absolutely.
So sounding good. Thank you for
That was
that.
it.
Thank you to Senator Woods.
Yeah,
Yes.
Mr. Chair. Mr. Chair,
Yes.
I just wanted to say, I think that's really great. And I wanted to ask Mr. Byrd a question. Does the proposed legislation do what we had talked about on the bench more than once, which is to get a little, try to structure ambulance service so that it isn't confined to the areas that they're confined in, which works at inefficiency when they're not well enough staffed. Does it address any kind of structural change like that, or can you say, Commissioner Byrd?
I don't, so I don't know exactly how it's written. I don't even know if Senator Woods has written the legislation as of yet. And obviously I don't know what our staff is recommending. We're going to go over that tomorrow.
Mm-hmm.
But I can tell you that what initiated Senator Woods's interest is that his home community, which is Grady, it's a volunteer ambulance service. And when the 2 approved EMTs are at work, they don't have an ambulance.
Yeah.
Right? Because they're working, so they can't respond.
Right.
So anyway, he realized that, that's a problem, that we can't send an ambulance out with just somebody who can apply pressure and get them to a hospital even. So that was the impetus basically for him getting involved. And as I said, he's willing and interested in any of the issues that have come up, and was glad to know that we as commission body want to get some of these things fixed as well. And so that's what I can tell you of what we've discovered so far.
Well, that's great. I'm glad to hear it. And thank you for working with them on it. And if you need any input or any thoughts or anything, I'm happy to visit with you more about it.
And Commissioner Byrd, on the plus side, I promise to stay out of your way until you have something together.
Yeah, then you're gonna be a stick in the mud.
Yeah, well,
he'd be out of the way until it counts.
Well, I've liked your ideas on this so far, so I don't know why that would be
right. Yeah, I think we all agree. I hope we do anyway.
Yeah.
Okay. Any other commissioner comments?
Mr. Chair.
Mask one. Go ahead.
I just have one announcement to make. My assistant, Christopher Hall, has passed the bar exam on his first attempt. And I have just a little, some statistics for you. The average pass rate of the first time test takers was 77%. The average for all test takers was 71%. So I guess the first timers kind of drastically increased the average pass rate. So Christopher Hall here just passed it. I don't know if you have any comments for him, or do you want to say anything?
I'll just say thank you, Mr. Commissioner, commissioners. Thank you to Commissioner Maestas. He was the first person to call, the second person to call to congratulate me. I was surprised that he even knew. So that was very heartwarming. And, I'm just old enough to remember when the calling to public service was one of the highest callings someone could aspire to. So I'm glad to be a part of the work, doing the work. I'm glad to be joining the bar eventually, and be approved to join the bar, and to be working for the PRC, doing the work for New Mexicans. So thank you.
Well, congratulations from all of us.
Absolutely.
Yes, definitely. Congratulations.
Okay, well, I think we,
Thank you all and thank you.
not at all. Yeah, great to see you, by the way. And I guess with that, we've completed our meeting, and until next week, thank you all.
Have a good one. See y'all.
Bye.